Verona send their well wishes to all of our speakers and to our audience members, and thank you all for your participation. Our rapid response webinars bring together a broad array of national experts on the day following the biggest Supreme Court decision of each term to explain and offer accessible commentary on these crucially important decisions. Our program today brings together over a dozen renowned scholars and leading lawyers who will approach the Trump decision from a variety of perspectives. Our hope is to deliver a program that is both descriptive and critical, theoretical and practical, urgent yet balanced. These annual webinars are a new Seattle U tradition and a small but important example of how Seattle University School of Law takes seriously its role and its obligation as a national center for discussion and study of the most pressing problems and controversies in law and policy. Before I introduce this year's program, I wanted to thank Joe Selmont, Colin Watrin, David Sandler, Neil Griffiths, Nicole Jennings, and Seattle U's IT professionals for all their help in organizing and administering this complex event. Today, we'll be discussing the sobering question of whether the Constitution accords presidents and former presidents immunity from prosecution for allegedly criminal actions taken during their time as president. This issue has been the subject of speculation in constitutional law classrooms and law offices for many decades, but has never before been the subject of a Supreme Court decision. Yesterday's decision was prompted, of course, by the 4 sets of criminal charges filed against former President Donald Trump in recent years, and in particular by the federal indictment related to his alleged attempts to subvert the results of the 2020 presidential election. In yesterday's decision, a sharply divided Supreme Court issued a 6-3 opinion adopting a broad view of presidential immunity. To oversimplify to the point of caricature, the court divided presidential actions into 3 categories: core executive actions, in whose exercise the president is absolutely immune from criminal prosecution; other official actions, in which the president is presumptively immune; and private actions for which the president does not possess any immunity. Where the court got these rules from, how they intend to draw the lines between these categories, and what the ramifications are for the pending Trump indictments and for the future of our democracy are exactly the kinds of questions that we're going to leave for our esteemed panelists. The discussion today will be broken into 2 panels. The first panel is titled, "What the Decision Means and What Happens Now." This panel is intended to remain more narrowly focused on the Supreme Court's decision, including the majority and dissenting opinions, and on the immediate ramifications for the criminal cases against Donald Trump. The second panel is titled, "Broader Implications for the Power of the Presidency and the Future of American Democracy." As the name suggests, this panel will zoom out to discuss the big picture over the longer term. Our first panel will be moderated by my colleague, Professor Pilar Hernandez Escotrillas. Without further ado, I invite Professor Hernandez Escotrillas and the rest of the first panel to join us on screen. I look forward to a lively and thoughtful discussion, and thank you all again.
Good morning, everyone. It's such an honor to be here. As my colleague noted, my name is Pilar Escotrillas. I'm an assistant professor of law. For those of you who are joining us on this webinar outside of the law school, I'm about to enter my 2nd year teaching, and my focus is really on criminal law, criminal procedure, and race in the law. So I read this opinion through that lens, and I just want to be honest about that. It was fascinating to understand this intersection, right, between presidential immunity and criminal law, and who gets the benefit of immunities and defenses. So extremely excited to moderate this incredible panel of folks whose expertise ranges from history to civil rights. And so just to offer everybody out there a little bit of sense of how we're going to organize this panel, each panelist will have about 7 to 10 minutes where they will offer their commentary. And then we'll have about 15 to 20 minutes, more or less, for questions at the end. So as, excuse me, as my colleague noted, for those who haven't had a chance to look at the opinion, might be a little bit confused, we're understanding that what the court is doing is creating a sort of tripartite analysis, right? They've sent it back to the courts to look at, in the first instance, whether particular acts are official or non-official, therefore providing the president with immunity or non-immunity. And so as we're looking to the future of what this all means for us, I'm really excited to introduce Professor Lee Kowarski, who is the Bryant Smith Chair in Law and at the University of Texas at Austin School of Law. Professor Kowarski, would you give us a little bit of sense of where we go from here? What are the next steps for the DC prosecution in this case?
Sure, yeah. There's so much to talk about, and perhaps the most concrete set of questions centers around my agenda for today. What is going to happen in this particular case? The case will formally go back to the DC Circuit, which will quickly turn around and send it back down to Judge Chutkan. Judge Chutkan is the district court judge in DC. She'll have a hearing on presidential immunity before the trial. Judge Chutkan had indicated that she would give Trump 3 months to prepare for trial, but that timeline doesn't actually control the timing of the immunity hearing. So I strongly suspect that she'll calendar the immunity hearing faster than she would have calendared the trial itself. My guess is that that hearing will happen before the election, although any chance that there will be a trial before the election has totally vanished. The form of the hearing isn't totally clear because there's no real precedent for it. But Judge Chutkan will presumably take evidence and make legal findings. And you're likely to see the court entertain argument on the sufficiency of the allegations in the indictment. Do they allege, sufficient non-immunized conduct? But I also think you're going to see the parties introduce evidence. They may do that on paper by filing briefs and attaching evidence to it, or they may call live witnesses. We just don't know. This is kind of a fascinating development because this occurrence means that we'll see lots of the bad evidence faster than we would have if it was only going to be introduced at trial. Somewhat of an ironic outcome of all of this. So what will Judge Chutkan use the hearing to decide? 3 things. First, she'll separate official from unofficial conduct, with unofficial conduct getting no immunity. Second, within the category of official conduct, she'll separate that conduct into official conduct that is core function and official conduct that is non-core function. Core presidential functions, those get absolute immunity. Non-core functions get immunity that is only presumptive. So the third thing Judge Chutkan will do is determine whether the presumptive immunity is pierced, which it will be if the prosecution shows that criminalization poses no danger to the executive function. After that hearing, Judge Chutkan will presumably take some time. She'll issue her decision about what conduct is immunized and what conduct isn't. And then the Trump team will have an opportunity for an interlocutory appeal, which I'm certain they will take. That will go to the DC Circuit. The DC Circuit will decide it. And then presumably one or both of the parties will seek further review from the Supreme Court. So as you can see, the presence of interlocutory review means that this process will inevitably take an extraordinarily long time going forward. Although, ironically, we may see some of the worst evidence sooner than we would have seen it if the Supreme Court went the other way. And with that, I throw it back to you.
Thank you. I'm wondering if for Professor Kowarski, for some of our attendees, whether you can provide us some examples of what the court identified as squarely official. So the speaking to the attorney general, that sort of thing, just for people to understand what this means in practice.
So the Supreme Court outlined 4 buckets of evidence. The first bucket was the conversation that the ex-president had with folks in the Justice Department, where he was basically jawboning them into sending fraudulent letters to states threatening them with lawsuits if they didn't revise their electoral counts. And the Supreme Court says this is clearly official conduct. Not only is this clearly official conduct, this is clearly core presidential function that gets absolute immunity. So that's off the table. Everything else is on the table. So, for example, the Supreme Court also said that conversations with Mike Pence are very likely to be official conduct. And so it seems like the district court will need to confirm that, in fact, it's official conduct, and if so, decide whether it's core function or whether it's non-core. For the rest of the evidence, that is evidence of Trump's conversations and outreach to various state and local Republican officials, as well as his tweets and other communications around January 6th, the Supreme Court has said that it's not sure whether it's official or unofficial. So all of that evidence will have to be classified according to the rubric I set forth about 45 seconds ago.
Thank you so much. And with that, we'll pivot to our next panelist, Smita Ghosh, who is appellate counsel of the Constitutional Accountability Center. She's also lead author of the amicus brief for constitutional law scholars. Would you, Dr. Ghosh, please share with us your view of how history does or doesn't or hasn't or will play a role in how the court viewed this case?
Sure. Thank you. Just starting out, thank you so much to all the co-panelists and to SU for arranging this. Yeah, I work at Constitutional Accountability Center, which is a law firm and think tank that tries to use history to inform constitutional and statutory debates. And we regularly file amicus briefs, including the one that you just referenced. So I did have the opportunity to think a lot about the historical evidence in this case, and I know that Professor Brewer is also on here and filed a great history brief as well. One thing I thought I could emphasize as a starting point is just that there's no constitutional provision stating that the president cannot be tried for actions taken during the presidency. And there is historical evidence suggesting that that was intentional, that the framers considered the opportunity to create some kind of textual provision and explicitly rejected it. There, in the drafting history, Madison raised the possibility of attaching some privileges to the presidency, and it wasn't addressed. Nobody took him up on that invitation. So the majority opinion didn't use the text of the Constitution, and they didn't use much history either. They reasoned a lot from what I thought were more like free-floating separation of powers principles, penumbras, something like that. And one thing that felt important to mention was a civil immunity case from the 1980s called Nixon versus Fitzgerald. That was a case involving President Nixon, at that point a former president, and asking whether he could be liable in a civil trial for actions that he took as president. So a civil trial meaning just for damages rather than with the possibility of being incarcerated. And the Supreme Court there recognized, using again these like principles, that the threat of civil suits about official actions could really hamper the president's decision making. And I wanted to bring this up just because I'm curious what other panelists thought about this, because the court did try to explain why that threat of kind of hampering the president's decision making, making them unduly cautious because they're worried about being sued, why that would apply in the context of a criminal prosecution. But to me, Fitzgerald was kind of about a balancing test. What's the interest to be preserved by letting the suit go forward versus the interest in protecting the presidency? And it just seems like, at least arguably, there's a lesser public interest in action for damages than there would be for criminal prosecution. And this gets a bit circular, but just thinking that prosecuting someone and deciding to prosecute someone is part of the executive power. That's an interest of the executive branch of the sitting president. And then, so to say that it should be kind of held back because of the interest of the former president, I just found that really interesting, and I wasn't totally expecting the court to go there in its reading of Fitzgerald. So then thinking a little bit more about that, you asked about the history. There was quite a lot of supportive history, I thought, that the court disregarded. I was expecting a little more, I guess, engagement with that. One thing that I found, I'll just mention it, that I found especially convincing, that I relied on a lot when preparing this brief, was an article by Sai Krishna Prakash. He's a professor at University of Virginia, and has written a lot about kind of pretty broad theories of executive power. And he has an article called "Prosecuting and Punishing Our Presidents" that is about why the president is not immune. And I think he even extended his conclusion to a sitting president, not just a former one. So a lot of this is a story about kind of not just like what history is there, but what work do you want history to do? And I think that's where the majority and the dissent really differed. So, for example, there's a lot of statements from members of the founding generation, including some of the ones that worked on drafting the Constitution, that kind of directly acknowledged or shared a presumption that presidents could be prosecuted. Justice Sotomayor cited what I thought was a pretty convincing example of this in her dissent. It was a quote from James Iredell, one of the framers of the Constitution, later a Supreme Court justice, president of the North Carolina ratifying convention. And he said, I'm quoting, "If the president commits any crime, he's punishable by the laws of his country, and in capital cases can lose his life." So that's, for Sotomayor, was really convincing evidence that the framers wanted the president to be accountable, that the absence of text on this protecting the president from prosecution was intentional. But for the conservative majority, this just wasn't enough. The opinion kind of pointed out, it addressed that quote from Iredell and said, well, we don't know if he was talking about official actions or not. So we can't really, that's not directly on point. So that to me was just an example of kind of using history to ask different questions and to expect different amounts of kind of specificity. And that's attention, like in all uses of history, not just in this type of case. And I thought the same thing was true for what you would call like historical practice or post-ratification of the Constitution. For the dissenters, it was really relevant that for years people have acted like presidents were not immune from prosecution, even for official actions. There's like Ford pardoning Nixon, the Office of Legal Counsel writing in a memo that concluded that sitting presidents shouldn't be prosecuted, but once they leave office, of course, they can be. It's sort of like almost as an aside. So the majority looked at this practice really differently. It said, well, at the bottom line is that a Supreme Court has never addressed this question before. No one has ever raised presidential immunity. So it's really like, there's really nothing there for us to look at. A line that jumped out to me was, all that our nation's practice establishes on the subject is silence. So there's just to me, that was just kind of a sobering moment about like what history and historical evidence can and can't do in these types of debates. Like a cynical read is just kind of like, you can always shape the evidence to support or not support the argument you want to make or the conclusion you eventually want to end up with. But maybe a more measured way to put it is just that historical questions always change depending on the way you frame them, and then evidence becomes relevant or not relevant.
Thank you, Dr. Ghosh. I think that's a
much.
great transition into Professor Brewer, who is the Burke Chair of American Cultural and Intellectual History at the University of Maryland, and also a lead author of an amicus brief, particularly the one for American historians. Professor Brewer, in linking what it is that Dr. Ghosh has just highlighted for us, can you talk to us a little bit about what this means for prosecution? How does this engagement with history impact, right, moving forward, how prosecution goes?
Right. So actually, I'm more critical of the majority on the Supreme Court than Professor Ghosh is, because the historical record is not, in fact, silent. it might be silent in terms of previous major Supreme Court decisions, but it is not silent in terms of the constitutional records, in terms of legal treatises from the founding era. It speaks loudly and clearly, and that's part of the reason I got involved in writing the brief at all. The major treatises that were used to train generations of lawyers and judges that were written by federal court justices in the founding era, such as those by St. George Tucker and Joseph Story, who was himself a Supreme Court justice. That's the first major treatise in constitutional interpretation, all explicitly address these questions. And in fact, there's a section of Story's treatise that even deals with what one could call official acts. He talked about the duty of presidents to the take care clause of the Constitution, and says in performing their official acts, they can't be questioned immediately at the time, but immediately afterwards, if there's any problems, they could both be impeached and or punished by courts of law if they step beyond the pale. And so I didn't include that because we ran out of time, and during the oral arguments, I was feeling it's like, oh my gosh, that really did have to be in there, and we ran out of words. But honestly, regardless, there was so much historical evidence, and the Supreme Court, the conservatives on the Supreme Court, who's claimed to be originalists, chose to ignore it. It is willful silence because it didn't fit with what they wanted to do. And I will add this explicit point. Trump's lawyers, at the point that the Supreme Court decided to accept the case, the core of what they were claiming was that chief executives under the common law, that is kings, had the privileges of immunity, and that the common law continued after the revolution, and that therefore that presidents had the immune powers of kings. And we completely focused on that issue and we destroyed it. So they did not refer to that. And yet, what shocked me above all is that the essence of their decision, and particularly the statement that essentially said that, this is on page 5, nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. That point essentially says, even if it's clearly criminal behavior, if it's official, it's just fine. You can't even investigate it. You can't present evidence about it. That this line put this case into the category of one of the most heinous decisions in the whole of English or British law, which is a 1686 case called Godden v. Hales, which literally said that the king does not have to abide by the laws of the realm, which was totally corrupt, by the way. All the justices at that point literally held their positions at the pleasure of the king. Imagine if the Supreme Court held their positions at the pleasure of the president, and you could be fired after. Anyway, that was actually done in this case. And became the focus of the Glorious Revolution because it led James II down the route of huge abuses of power that made him unpalatable. So what I see is that this case is creating a fundamental shift in the balance of power in our Constitution that is just a ticking time bomb in terms of creating dictators. And in terms of the prosecution of this case, on the one hand, it looks like some parts of Jack Smith's prosecution could possibly go forward, but there are so many evidentiary hurdles that are created as well by this case that any behavior that might fall into the category of official acts can't be used as evidence. Like, this is huge, even in the prosecution of non-official acts. And the only example that they clearly give of a non-official act that could be prosecuted was quite literally the case of prosecuting former President Clinton for lying about having had sex in the Oval Office. This is like, what, a coup cannot be prosecuted because that probably falls into the category of official acts, but I mean, a lying about a sexual act can. I mean, what kind of a country are we headed in? And I was made a little bit hopeful by Lee's comments that maybe some of the bad evidence will come out, but on the whole, this is a stunning decision. It is a decision that echoes one of the worst decisions in favor of absolutism in the whole of British history. And the fact that the Supreme Court seems to have gotten here on their own, despite the historical evidence, is shocking. To me, it made me think about the entire Supreme Court differently than I had before. It makes them seem like unserious partisan hacks.
Yeah,
And
you know what?
I mean,
Oh,
oh, sorry.
no,
I was
please
very
go ahead.
inspired by what you were saying, so I wanted
Please
to
go
jump in
ahead.
just to say that one, that this is a court that professes to care a lot about history and tradition, and especially the members of the majority that wrote this opinion. So that is just an added gloss for me.
Was thinking a lot as an archaeologist by training, a historian, an anthropologist. I was thinking so much about the citational politics that I saw in this opinion. And one example that really struck me in support, of course, Youngstown, but also in support of this idea that official functions are within the exclusive role of a president, can never be sort of questioned, was this example of U.S. v. Klein, where after the Civil War, President Lincoln offered a full pardon, restoration of property rights to anyone who had been engaged in the rebellion, right? And I thought to myself, as a historian of race and race making, what is the work that this citation does, right? To sort of link back to one of the most violent and tumultuous moments in history to legitimate why this current decision is so necessary, right? To say, well, in that event where people were property, right? The restoration of all but the people property rights suggests that lends credence to this statement, right? So I was thinking so much. I don't know if other folks besides the historians in the room were thinking of these citational politics and what that means. And to your point, Professor Brewer, about the personal and the private sphere being linked solely to the example of Clinton, right, leads also to some additional questions that I'd like to raise after this panel about political implications beyond simply this decision. Anyone have any thoughts on that before sort of moving on to the rest of our panelists? Sorry to interject there. Maybe that can be some of the content moving forward. Oh,
No,
Dr. Ghosh.
I did. I
Oh,
didn't pick
okay.
up that. I didn't pick up on that with Klein, but in a couple of other articles I've written, I've noticed how, especially with the Roberts Court, the conservatives, in order to legitimize some kind of decision that's conservative today, will cite back to racial oppression as a reason to justify why they have to do it. So, for example, in the gun cases, Second Amendment cases, what made them so convinced that history and tradition supported this being a fundamental right, therefore incorporated, was the experience of Blacks in the South during Reconstruction when they were dispossessed of guns and the Southern states were not helping them. So they were writing letter petitioning Congress asking for assistance. And the response was, yes, you have a right. All right. We see that even in the affirmative action cases. Why do we apply strict scrutiny unflinchingly? Well, because historically people of color have been really subordinated by race. So we always have to treat race seriously today. It's interesting that you picked up on this pattern here, but others, like I think Melissa Murray may have mentioned that in an article she has on Dobbs as well. So I think it is a pattern with this court. I'm not sure what it means. On some level, it could be we're taking the high ground, right? It looks very like a moral stance when you're looking back and they're saying, okay, we're siding with Congress who was protecting the former slaves, or we're siding with the civil rights movements by having this colorblind approach. So that certainly could be part of it. And I'd like to see what others do as they excavate this decision more.
Thank you, Professor Hutchinson. I didn't introduce you, so let's take a moment to do that. You were the inaugural John Lewis Chair for Civil Rights and Social Justice at Emory University School of Law. And maybe that's a great transition into sharing some of your thoughts about what are the standards that are articulated here? Are there any that are clearly easily for lower courts to follow? For example, the timing of the ruling and political climate. So,
All right, thank you. Yes, so my mind was all over the place. A lot of times when there are these opinions that people have just been waiting on forever, there's this huge bang, and then I look at it and I'm like, well, does it do all of that? And so as I've been listening to the comments, I'm like, it does all of that, but it doesn't do all of that. So I guess I'm kind of in the middle here. I think on some level it's classic Roberts. Like he's writing all this stuff and he's saying we're not doing anything drastic here. I love the section he put in there saying the government had this very sweeping notion that the president could be is not immune from anything that happens during the presidency, right? And then on the other side, Trump's lawyers had this reverse side, and here we are in the middle, right? And so that looks like we're taking a compromised position. We could have chosen from these two radical sides, but that's not what we're doing. So we're in the middle. Plus, we're not going to even decide most of these issues. We're going to send it back to the district court because they're all heavily factual, and we need the trial court to do that at first glance. Cases are not made in the Supreme Court, right? At the same time, however, when you look at these standards, as others have pointed out, there could be a lot, and in the wrong hands, or I shouldn't say the wrong hands, depending on whose hands these cases are in, the implications can be startling, right? Trying to unpack core from non-core, trying to determine what's a danger to the functioning of the executive, all of those things, courts are going to have to decide. And I think it's an interesting, this case following the reversal of Chevron, the court is really becoming this powerful institution where it's looking like, hey, in this situation, we're protecting the executive, right? In the other cases, we're protecting the voters because, you know, the Chevron thing, the agencies are going amok. But at the same time, hidden beyond that type of rhetoric, the court is becoming enormously powerful. And we had already seen that, obviously, in a lot of cases where precedent is ignored, overturned, etc. But now in these cases going forward, implementing the rulings is a very judicial centric process. So courts are going to have to sit down and make all of these decisions. Well, hopefully, we won't have a president committing high crime felonies during office, but to the extent that that comes back, it's a judicial function to interpret all of this stuff. So the grabbing there was very interesting to me. Another thing, in addition to the history being missed, and I think the case that really, where the court really went through it, but then said history was a wash, was the Clinton Jones case. There's a lot of discussion of history in that case. Here, it was just fleeting. They really were not going to go into that. I'll leave it to you to determine why they ignored history, but also the text. I thought it was interesting that Roberts really summarily rejected Sotomayor's arguments about, you know, this is not an explicit privilege. And so he just said, well, we know that, but we've already held that the privilege exists, but she was kind of getting at something else. And actually, if you read these other immunity cases, the court does this a lot. Presidential immunity doesn't, it's not exist in the Constitution. The framers explicitly gave it to members of Congress. They could have given it to the president, but they didn't. What are the implications of that? That doesn't mean that there's no immunity. It might mean that the way we interpret it is different, that we have to be cautious in extending this privilege that is not recognized textually like the others. And another piece of that is maybe we should balance it against other interests, all right, which I think this conversation kind of melted away. The administration of criminal justice, all right, that's something that comes up a lot in the privilege cases and immunity cases involving lower executive officials. Thinking about the administration of criminal justice, that conversation kind of dwindled away from the opinion, and the discussion becomes how harmful the administration of criminal justice is on the executive when it usually in those cases it's the reverse thing, that it creates this extra interest that kind of goes against the person asserting immunity in these types of cases. Let's see. I think the final point I will add has to do with the legitimacy of the court. And we hear this a lot. Scholars have written about it a lot. Historians, political scientists, law professors. the erosion of legitimacy. And it's the best argument I can hear about what happens when legitimacy is eroded is, there's a lack of public trust. It can demoralize people's faith in our democratic institutions. It can also cause people to ignore the Supreme Court to the extent that they have power not to follow the court's decision making. And I think that we certainly, after the last 4 years, maybe, we're in a situation where maybe the courts, definitely scholars and lawyers should take this claim a bit more seriously, right? We have Dobbs, we have this opinion, which could have very drastic implications depending on how it's implemented going forward for our democratic institutions and the power of the presidency, right? And it's hard to shake, although I don't believe all of those sort of conspiratorial arguments about the court was intentionally laying, the court took this case because it wanted to be a lawyer for Trump. That may go too far, but on some level, it's hard to shake the impression that this was a partisanship and ideology that determined the outcome of the opinion. And there was no sort of reflection and thoughtfulness that is warranted in a situation like this. And I'll close by saying that Barrett's concurrence, right? If I'm going to get a conservative opinion that's thoughtful, it was her opinion, which Roberts responded to in a footnote of all things, right? So those are my comments. It's going to be interesting to digest all of this stuff, and I want to thank you all for inviting me to participate.
Thank you so much, Professor Hutchinson. I'm wondering if you can also, as a follow-up, provide some of our attendees a little bit of insight into your thoughts on Justice Barrett's concurrence and what she chose to concur with exactly and what she chose not to concur with. There's a section of the opinion that,
right. So she actually, there are a couple of points. So she thought the court could have decided some of these other issues, like Trump talking to talking to a crowd of people who later went to the Capitol building to stop certification of the election. Those are private individuals. There's no executive function in that. They should have just called it rather than remanding, right? And I actually agree with that. The other thing is she disagreed and explicitly stated her not agreeing with the majority on this particular point about evidence, right? That if the evidence comes from official activity, then it cannot be introduced even when the prosecution concerns unofficial conduct, right? And that's, I agree with her for doing that. The implications of that from a prosecutorial standpoint are just litigation generally, cutting off all of this evidence, even if there's immunity from damages, if there's immunity from prosecution, that's a particular thing, to say that that cuts off the use of that material from any other proceeding is frightening, honestly, and it sweeps very broadly into aggrandizing the power of the executive.
Thank you. Our next panelist is Professor Claire Watford, Associate Professor of Political Science at College of Charleston, and also author of commentary on this case from a political science perspective. Welcome, Professor Watford. Love to hear your thoughts as to what this means for political scientists moving forward, how you engage generally perhaps with the law as well. It might be helpful for some of our viewers.
Great. And well, I'm glad you asked me that because I actually, it's nice to see y'all. Forgive the pushy cat who was in here. He got put into the bathroom, so hopefully he'll leave me alone. I hope you don't mind. I went ahead and just sort of typed up my thoughts because I think, as others have said, my mind is kind of still spinning in a million directions after this decision, but I am delighted to be here today. I do have to leave early, unfortunately, but I look forward to hearing what everyone else says in the recording. So as Pilar mentioned, I am a political scientist, which may give me a bit of a different perspective here that I hope is of some value and not telling you what you already know. And so I went to law school first, but I was trained later in grad school as a quantitative methodologist. So I use science and statistics to try and unpack judicial decision making. And among those of us, those political scientists who study the Supreme Court, their decisions are generally viewed as the product of some mix of three factors, right? Ideological preferences, strategic considerations about other political and legal actors like the other justices, Congress, interest groups, lower courts, and then the law, what we might call legal factors or legal concepts. And probably because I was brainwashed as a legal thinker first, I've spent my academic career so far trying to demonstrate that law does exert some kind of constraining effect on the justices' political preferences sometimes, right? That they are not just politicians in robes who use law as a fig leaf to disguise their ideological preferences. What I try to demonstrate, what I believe, maybe believed, is that law in some way matters. Now, this unfortunately is really hard to do from a social science perspective, right? It requires defining law, whatever that is, in a way that can be measured reliably and captured in a statistical model, which is not an easy task. However, there's been good research, as I'm sure you all know, over the last 10 to 15 years in the political science literature that shows that while judicial ideology is indeed a major factor in why the justices rule as they do, particularly in certain types of cases, it's not the only explanation for their behavior, right? Precedent, the facts of a case, the quality of briefs and oral arguments, the repetition of legal arguments by amici can all shape both the outcome of a case and the content of an opinion. So I generally believe that, and I try to use my quantitative skills to prove it. So to state the obvious point, I don't think Trump versus United States is going to help my case very much, right? The clear ideological split is, of course, the big headline. And I think that along with Bush versus Gore, it's going to be forever seen as a case in which the Supreme Court seemed to favor their political side and helped elect a president. And I think Roberts' takeaway line, immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party, just rings hollow, particularly because of how extreme the opinion actually is. Now, setting aside law for just a minute, I also don't see a lot of evidence in the opinion of the strategic bargaining among the justices that we political science might have expected, right? We know that in many cases, there's a lot of back and forth negotiation during the opinion writing process that can sometimes moderate the opinion content and result in legal rules that are more nuanced and balanced than what we saw here. And in fact, even though, as Darren noted, of course, Roberts wrote the opinion, I actually see Kavanaugh, Gorsuch, and Alito all over it, right? In oral argument, Gorsuch was really concerned about looking into the president's motives and how many problems that would create. And Kavanaugh was brought up what became the core powers part of the opinion. Alito went on and on about the needs of the president to function without the fear of these crazy roving prosecutors. And I actually thought during the oral argument that Roberts was thinking more moderately and kind of struggling to figure out how all these things would work together. But as I think we all agree, the majority went really far here. I think much further than they had to go to give Trump a win, right? The removal of the considerations about motive, the limitation on the use of evidence, the language from Blassingame about an act being plausibly within the outer perimeter of a presidential official acts, the incredibly high presumption of immunity that the government has to overcome, showing that what they're going to do is going to have no interference with the functioning of the executive. None of that had to go in there to give Trump some kind of legal victory. So the point I'm trying to make by all this is it looks to me, if I had to guess, that Robert basically just got run over this time by the three other conservatives, or he just kind of gave up. And it makes me wonder what, if anything, he got in return. So I'm really looking forward to maybe Linda Greenhouse doing some great reporting, or at least getting some look at some private papers a few years from now. Which will be super fascinating to me to find out what happened, because I don't see Roberts' more moderating concerns about compromise and institutional legitimacy operating in this case. Do I have just a few more minutes, Pilar, to say one more thing?
Yeah, you do. You have a good number,
Okay.
about 5 minutes.
So to continue ranting, I think how far the opinion went is not the only problem with it. So I'm going to take off my political science statistician hat here and think more broadly. And Darren spoke to this too about the role of the court. And I was one of those who was actually in favor of the court taking the case. I mean, I'll just say up front, I'm no fan of what Donald Trump did about the 2020 election, but I do believe that it's the court's job to take major constitutional questions and resolve them well. And what I'd argued in some commentary was that the court should take its time in making a decision. And I was hoping they would use that time to craft some sort of workable and rational legal rule about official versus unofficial conduct that the lower court could use and that would fairly balance the considerations at play. The way I saw it, the court expanded the question presented to define not just whether or not the president had immunity, but to what extent. And it became clear during oral argument that the official versus unofficial act question was going to be key. And I was hoping the court would take some time to give a legally sound dividing line. So I never thought Trump would in any sense lose the case, and was actually, relatively fine with that per se, but I'd expected a legal test to come out of the opinion, the kind which we're all familiar, some kind of maybe explicit balancing test that thought hard about all the competing needs here. And I thought it was particularly important that the court be really careful and thoughtful in this case, perhaps above all the others, given the decline in public support, the political divisiveness of the country, etc. And I was hoping Roberts, who I thought would write the opinion, would be willing to compromise, and his concern about the court as an institution would tamp down some of the ideology of the more radical conservatives and result in a tangible, reasonably coherent legal test. Instead, what I think we got from the court was what they call guidance and considerations about what might be official versus unofficial. They make this offhand reference to things that are manifestly or palpably outside the official duties, but they basically punt it back to Judge Chutkan to figure it all out. And so the case is a big letdown for me, not just with what the court did, but with what they didn't do. We got what to me looks like an extreme ruling along ideological lines that is really going to do nothing to help those of us who want to argue that the court is meaningful, the court is different, the court is, if not totally removed from politics, at least not smack in the middle. And, Darren mentioned, and I think he's correct in a lot of ways, the court has been roundly attacked this year for being too powerful, for asserting itself into spheres like the administrative state where it doesn't belong. But to me, Trump versus United States is an example of where they had an opposite problem, right? They failed to take advantage of what is in their sphere and what they should be doing, formulating workable, coherent legal rules. And somehow today's court sees itself as able to resolve questions about smog and fishing boats, but they can't give us a good legal test that works under our Constitution. Thanks.
Yeah, thank you so much, Professor Wofford. The lack of real clear direction to the lower courts, right? What is the test meant to be employed? How do you assess whether something is official or non-official? And what role does the person, and as I don't think we've actually mentioned this yet, but motive, right? What role does motive play in this analysis? None whatsoever. So to my mind, thinking through mens rea a little bit more, right? Speaks to whether something is in fact official or not. If the intent with which somebody is acting and comporting themselves and behaving, that would tell me whether it's Trump the president, Trump the candidate, or Trump the individual, right? I don't actually know how you assess how the president is acting as the not president in that moment, right? So I think there's a real lack of clarity in terms of when is the president not the president, even if I guess the answer from the court is that if he can do something he's allowed to do under the Constitution or the statute, he is always the president. But that's also seems to be a counter. There seems to be a counter argument that within the majority opinion as well. So I didn't have a lot of clarity on that question. but thank you for raising at minimum those issues. Professor Brewer, did you have a follow-up?
Yeah, just really quickly, they didn't give a lot of clear guidance, but there's so much in there that is going to prevent the evidence from even coming forward. They're saying they're specifically saying you can't pay attention to intent about whether it's supposed to be an official or an unofficial act. There's just it's made it really, really hard to find a way forward. So it's muddying the waters on multiple scores. And I wanted to just say really quickly that having been at the live oral argument that day, what was especially shocking and especially striking in the moment was almost exactly halfway through, and this gets to the point that Professor Wofford was making. Chief Justice Roberts was in the middle of asking a question, and he asserted that, quote, the fact of prosecution was enough to take away any official immunity, end quote. And Michael Dreeben, who was arguing the case on behalf of the government and for Jack Smith, says, I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. And that at that moment, Robert seemed visibly taken aback and also really listening. And it really did seem to me, especially also Amy Coney Barrett seemed to be siding with the other women on the court, that in fact this might come out a more moderate decision, but instead it came out far worse than I could have imagined even when I started writing our amicus brief in December. It looks, yeah, sloppy.
Yeah, I think my big takeaway is it looks political, and therefore it is going to be perceived as political, which I think is unfortunate. No matter how you feel about Donald Trump, it's unfortunate if you care about the Supreme Court, in my opinion.
Professor Hutchinson, did you want to add a point? Oh, you're on mute.
So about Roberts, I wonder a couple of things. One is, have the goalposts moved for him with the additional conservatives on the court so that his compromises are more to the right? That's one option. The other thing to me is and maybe that's the real cynic in me coming out, is I thought his compromise was not on this round saying Trump is immune on all of those things. We're just going to send it back to the lower courts for them to decide. I suspect that there are a lot of those other conservatives in the majority who wanted to just rule definitively that immune on all of them and call it a day. But that's not what happened. So that's where I was thinking there's a compromise, is because it could have been even worse. The headlines could have been Trump has been found immune by the Supreme Court. So, and the fact that there was no trial court proceedings with this new standard they've crafted, I really don't think that matters to them in many ways, but that's where I saw compromise.
Professor Kowarski. You're also muted. Okay.
So I don't generally get into the game of speculating about motives. You quickly piss people off and it's always unfalsifiable. That being said, I think we should remember that, you could understand this, the 6-3 majority is they, not an it. And at least two members of that majority are two of the most famously pro-executive folks to have been appointed to the Supreme Court. So, if you want to read the opinion through the prism of a justice that cares deeply about unfettered executive prerogative, I think it starts to make a little bit more sense. For instance, at every moment where the court had to make something that looked like a common law judgment call, they would wave at the fact that there would be some increment of executive autonomy, the license to be bold and unhesitating in action. Any increment of that value would outweigh all of the other interests on the side of the democratic scale, over and over and over again. So I would just suggest that as an alternate frame for understanding at least potentially some of the votes running in favor of the outcome. And so maybe it makes a little bit more sense from that perspective. But that's explanatory, not justificatory on my part.
Thank you. And as we move to our final panelist, I'm thinking a lot about what I have speculations about what this means for elections moving forward in November. And I was so drawn to a particular point in the slip opinion at page 10, for those of you who are following along, where the court identifies that the framers, quote, sought to encourage energetic, vigorous, decisive, speedy execution, right? In contrast to that executive who would, quote, be a feeble executive who implies a feeble execution of the government, right? And I couldn't help but think of a lot of that conversation, of the work of that paragraph, as reflective of or in conversation with part of the larger dialogue that is currently occurring with respect to the upcoming election, right? So I'm curious, as we introduce Professor Levitt, who is professor of law, and Gerald T. McLaughlin Fellow at Loyola Law School, also a former White House senior policy advisor, I believe the first for democracy and voting rights. We're super happy to have you here. What are your thoughts, Professor Levitt, about what can we glean from this opinion moving forward? What kinds of conversations are the justices engaged in?
Yeah, so great questions and great thoughts all. I also want to start off first with a thank you to Seattle and to Andrew and Pilar and my fellow panelists. This is an amazing discussion. And I'm reminded of what Pam Karlan usually says when she's sitting on panels. Everything's already been said, but not yet by everybody. So my job is just to repeat and summarize in different ways. And I'm going to take the first point to respond directly to Pilar by putting what Claire and Holly said in a very different way. Not that they would subscribe to this, but this is really an opinion from the legal upside down. The opinion asserts that this entire immunity structure comes out of the separation of powers. And if you take this from 1,000-foot or 100,000-foot level, the framers installed separation of powers to ensure that ambition would check ambition, to make sure that the branches would check and balance other branches. The version that comes out through this opinion when twisted through the upside down is that there's a need to protect one branch from all of the others. And it's the most dangerous branch that they need to protect from all the others. It's the branch that is in charge of the executive authority, that is in charge of the military. And I think Lee's absolutely right that this comes from a place of deep commitment to executive strength and executive authority, as you mentioned, Pilar, in your quote. But to such an extent that they feel they need to protect this executive because of the separation of powers. And they kind of forgot about the first principle, the genius of divided government, so that no one branch would be more powerful than the others, or as powerful as the executive they had just emerged from. Something else that Pilar has pointed out, also Justice Sotomayor in her dissent, Smita called this out as well. It is deeply weird that the majority feels it has to create this immunity because it doesn't want presidents to be shy, even in the face of plausibly criminal conduct. I actually understand the instinct towards civil immunity, but it says we've got to make sure that presidents can go right up to the line of criminal conduct because we don't want to deter them from engaging in plausibly criminal conduct. I want my presidents to be deterred, to steer away from plausibly criminal conduct. That's a bizarre thing to want to specifically reach out to immunize. In fact, to such an extent, as Darren mentioned, that you have to steer so hard toward protecting that potential criminal liability that you can't even use acts as evidence in prosecuting the president for unofficial acts. Given their ruling, I'm not sure you could ever get a successful prosecution for either treason or bribery, both of which are very bound up in official actions. That is, I'm not sure you could actually accomplish a prosecution for treason or bribery. And those are the only two specific crimes called out in the impeachment clause of the Constitution for which, as Justice Sotomayor pointed out, the framers were very explicit that impeachment was only a precursor, not a protection, to later prosecution. That is, the framers specifically said, if we impeach you for example, treason or bribery, you can be prosecuted later. And I wonder if that's still true after this opinion. So there's a lot that I disagree with legally in the majority opinion. Coming back to the electoral consequences, this may seem like an odd disconnect, but I'm going to really focus my remarks on disagreeing with one part of Justice Jackson's otherwise excellent dissent. She said that having immunity in this fashion means that the law doesn't apply to the immunized person in the first place, that this effectively creates an exemption from criminal law. And I see this opinion very, very differently. I think the immunity opinion creates an exemption from criminal consequences. But I feel really strongly about that not being the same as an exemption from the substantive standards of the criminal law. That is, it's clear that the former president can't be prosecuted for official acts, but that does not mean that the acts are somehow absolved of their criminality, even if there can't be a proceeding imposing liability for them. We won't have a criminal verdict before the election. As Lee said up front, that is abundantly clear. It may be that at least for some of this charged behavior, we won't have a criminal verdict ever. We'll have to see, as he says, about how they sort out, even though the court allowed for prosecution for some non-official acts, and even though those prosecutions may go forward, they're not going to be so cramped in the evidence that they can use to prove those acts that I'm not sure we'll get to a verdict. But particularly for the electoral consequences, I don't know that we need a criminal verdict, and I don't know that we ever did. The criminality of the conduct is still there for us to see. And we all know criminal trials provide one form of closure, one form of resolution, but they're a very different purpose than informing the public about what happened, or even allowing people to evaluate whether they want to hire someone as a chief executive. That is, the only thing a criminal trial does is it speaks to whether 12 people found a particular person guilty because their conduct met the following legal standards beyond a reasonable doubt, given the evidence in this case. We can ascribe consequences to criminal liability beyond that, but that's not really what criminal trials are for. And that's particularly true in this case, which wasn't like most crimes. This isn't a whodunit. This isn't really a what did they do? This is a case where the facts have mostly been very public knowledge for a long time now. And we, the American people, aren't used to that going into a criminal trial. It's not normal to have someone walk into a bank, walk up to the teller, pull a gun on the teller, demand the money, and then walk out of the bank and hold a press conference in which they say, hey, guess what I just did? I just walked into the bank, walked up to the teller, pulled the gun on the teller, and demanded all the money, and then walked out, right? That's not how criminality usually works. And so it can be very disorienting for people to think, well, we're not going to have a criminal trial here, so we won't really know. When we really know, actually, all of the facts, or the vast majority of the facts that have led to this criminal trial, this prosecution, are now public record. We effectively have a jury not of 12, but of 330 million. And even as Lee says, if a mini trial is held or a mini hearing is held where bad evidence comes out, where it's put on the record, it's highly unlikely that any of that will be a surprise. It's far more likely that it'll be a reminder. But we already have the tools we need to know whether the law was broken, whether the Constitution was broken, whether we, the people, want the person alleged to have done the stuff that is public record to be the chief executive again. And so I think we shouldn't feel restricted by not having the closure that a criminal verdict provides in this particular case. in making an electoral assessment. It's also true that criminal prosecution and the prospect of criminal prosecution is important, but I don't think it was ever the biggest deterrent to unlawful conduct by a president. There are very few presidents, thankfully, who evaluate their day-to-day responsibilities in office by thinking to themselves, could I be prosecuted for this? They're going to do what the office requires. This opinion makes it abundantly clear that criminal prosecution isn't going to be an effective deterrent in many further cases, which makes the importance of the electoral choice even more apparent. Effectively, the court has said to us, if you don't want a tyrant in office, don't put a tyrant in office. That's an option that's available to us, right? The plane is engineered and built and ready to fly. The American people are in charge of hiring a pilot. Don't choose someone who's going to fly the plane into the ground. And that continues to be the primary defense against wrongdoing, certainly the primary defense the framers thought they were installing against wrongdoing. I'll also say that the importance of our electoral power, right? That it can feel like a lot of agency is being stripped by this very muscular court from the people. But our electoral power does not stop at the president, does not stop at the Senate or the Congress or local office. We have lots of authority to choose how we want to govern ourselves. And I do think the institution of the Senate is incredibly important in making sure that ample deterrents exist even outside of the criminal prosecution process. We had a Congress already deem the former president, Donald Trump, disqualified from holding office again by a majority vote. A majority of the House and a majority of the Senate voted to convict on the second impeachment. They just did so in a proceeding that had a higher threshold than that, right? So it didn't have immediate legal effect, but more than 50 senators voted to convict on the second impeachment. And one of the articles of the second impeachment was a resolution that under the 14th Amendment, that the former president shouldn't hold office again. With a little more, I'll say, choice of country over party, and a little different personnel in the Senate, that vote might have come out differently in either direction. And those choices too, I think, should be on the electorate's minds, because after this opinion, now more than ever, the check of impeachment, which the House and the Senate have, looms even more important as a check against potential presidential wrongdoing, criminal or otherwise. And I'll leave the thoughts there. Send it back to the rest of everybody to discuss.
Thank you. Before we open it up to our panelists to ask one another questions, if there are any, I just want to note one quick announcement. Our audience, we want you to interact with us. Please submit questions. You can use the Q&A function. We have 20 minutes at this point, so we do absolutely want to incorporate audience questions. Do the panelists have any questions for one another before I kick us off with a question I have lingering? Professor Brewer?
Yeah, I just wanted to add, I hear you loud and clear, Professor Levitt, in terms of, yeah, a lot comes down to the voters, but one of the other things this decision does is prevent a lot of evidence from coming forward. So specifically the Nixon tapes, for example, would never have been shared, which is also, by the way, an explicit Supreme Court reversal. And so that it's going to be harder in the future, even though Congress can still play some sort of oversight role that isn't clearly clearly bound by these rules. It's going to be harder for even the general public to play that role. And also, I think there is a power in criminal punishment and not just losing office. And effectively, if there's no worry about going to jail or having money you took as bribes taken away from you, or any, you could talk about a long list of things, then the incentives are different. So it's just merely losing office, and who cares? You'll just go live on your estate and have fun with your, yeah, anyway.
Professor Levitt and then Dr. Ghosh.
Yeah, just really quickly, I don't disagree with any of the notion that the other incentives are also very important and that a tool has been taken away. I just don't want it to be, I don't want people to think that the only tool for resolution has been taken away. But to your point about the Nixon tapes, it's another measure of some of the, I think it was described as slop in the opinion. I don't honestly know. I read the opinion differently. If the prosecution's not of the president, I don't read this as overturning the ruling that evidence where the president is engaged or evidence of presidential wrongdoing is now immunized from use in a proceeding of a prosecution of someone else. But that's the way I read it. It's not 100% clear, and given their premises of disturbing the executive or disturbing the strong force of the executive, I can easily see a reading as you had, Professor Brewer. And that's part of the, I think, unfortunate slop in the opinion.
I read it the way you
Ghosh,
did.
Dr.
Sorry.
Ghosh, and then Professor Kowarski.
I didn't realize there was a queue, sorry.
Oh, no, that's okay.
Mine's not directly related, so jump in.
No, go ahead. I don't.
Okay, well, I was just thinking when Professor Brewer was just responding about the kind of value of criminal prosecutions, which is just something that struck me from reading all this historical material. The value of holding a president accountable through the criminal law was this big structural protection against the president becoming a British king. It was something that the framers kind of conceived as necessary for like creating this new system, this experiment that they were making. So it hugely important beyond this kind of like evidence sharing and other the other values. And that was an insight that I hadn't had until really diving into this historical material.
Professor Kowarski.
I was just going to say, I think a lot of times people get bored or they find it tedious when law professors talk about like, what's the normative reasoning behind one rule or another, right? And the tediousness is especially salient when there's lots of positive law to grab onto. You know, when there's the alternative is being a textualist or an originalist or something like that. But in a situation like this, where the court is obviously just engaged in a common law enterprise of making up a rule that it thinks is a good rule, they should be held to a higher standard. They should be persuasive in the way they balance various interests. And I keep coming back to how extremely sloppy and sophomoric the opinion was, specifically with, I don't want to say specifically with respect to lots of things, but when the court never deals adequately with the idea that there are all these protections that inoculate the president from criminal prosecution that don't protect him from suits for civil damages. And that panoply of protections means that adding an increment of immunity on top of that is kind of gratuitous. The unwillingness to even go there and to confront that argument on its own terms is either a product of writing the opinion fast or something much more depressing about what the court thinks it can get away with.
Thank you. So we have already received about 4 questions, I believe, if I'm looking correctly. So I think it might be best at this juncture with 15 minutes to read the questions out loud and just panelists respond in whatever order you all feel comfortable doing. One set of questions deals with positionality almost of the court, right? And the role of law and how we view it as the public. So Professor Sly noted it, the court demonstrates a level of humility in this opinion concerning deference to trial courts on fact-finding, which was noticeably absent in many other opinions this term. Is this just part of a compromise of not finding complete immunity, or is there something more insidious at play here, wanting to ensure no trial before the election? There was another question earlier on in our webinar chat from Joe. Does this decision increase or decrease respect for the rule of the law? Sort of connected to that view of how we view the judiciary. I see a trend in American society of less and less respect for institutions, including the entire legal system. Trump lost all court challenges of the 2020 election. And then we also have a question as to the role of what does this create for the executive, right? Is this signaling a de facto backdoor embrace of a unitary executive? What checks are left in response of in reaction to this? Do we have a check and balances at all? Can we protect from abuse from our president at all? And Howard Wasserman said that the court has recognized evidentiary privilege as an incident of congressional speech or debate immunity, accepting that there is an analogous presidential immunity. Why is it so surprising that it would also include an evidentiary privilege? And then we'll move into additional questions after. Any thoughts on those? Professor Levitt.
So I'll jump in really quickly on the last question of privilege. I would not have been surprised to see, as Lee indicated, a discussion of privilege and maybe a potential qualified or modified privilege. But the court's language across the board is profoundly absolute, and again, doesn't grapple with the downside of removing any of this potential evidence from the public domain. As distinct from the other decisions on effectively privilege, Nixon versus United States and Trump versus Vance, and even the questions on testifying in front of Congress for executive privilege, not the president himself, but president's high officers. The court always weighs the value of withholding the information against the value of disclosing it. And particularly in Nixon versus United States, the court was extremely emphatic that the value of disclosure, because of the criminal process and because of the public's right to know in a proceeding undertaken on behalf of the public, outweighed the very real potential concerns that a president might have for privacy. Part of the slop of this opinion, as we were just discussing before, is the logic here seems so different that although I still read Nixon as good law, I'm not sure the logic of Nixon pertains when you read this opinion in the immunity case. So I wouldn't be surprised by a discussion of immunity. I guess I'm surprised by the absolute character of the court's unreasoned approach to that immunity.
Professor Brewer.
Yeah, I just want to say that the historical evidence went so strongly against the position they were taking in terms of the founding era discussions of immunity, that I think it was hard for them to put anything in and say it with a straight face. Or, I mean, I know because I worked on these footnotes, and they didn't just go to particular sentences. They went into, 10 pages of discussion in Joseph Story's treatise, for example. And so that it was really, I think that's part of the reason it was so difficult. There was an explicit exemption of presidents from immunity, whereas parliaments, for various reasons, because of actually a long English history with which the founders were really aware, whereby parliaments needed some protections for what they said, because there had been cases where Charles I, for example, took soldiers and tried to arrest 5 members of parliament in 1641. So it's there that had been already well established, and that's why they put it in there. But they did not think it was necessary for the executive, because precisely of the fact of how much power the executive already had. They didn't need that protection. But in terms of the larger question, that was one of the other ones about are there any recourse as well? I mean, Professor Levitt laid some of those out, right? Voting. There's still impeachment, which is not nothing. And of course, the court's decision doesn't technically constrain what Congress can do in terms of these questions and collecting evidence. But I think the most important break is going to have to be, given that, in fact, literally, literally this decision seems to say that the president could order taking out half of Congress and still, right? Like literally, there's no boundaries, right, to what they've said in that sense. But I think the larger thing is it's going to have to be changing the court. We need probably to move towards appointing more justices. The court's been many different sizes over the years. Or try to impeach it, though that's really difficult. Some of these justices who seem hopelessly now compromised. This decision from a court that we do need to respect, which plays an absolutely pivotal role in our democracy, needs to be fixed. And so one of the answers is going to have to just be creating a new precedent that overturns this terrible one.
Professor Hutchinson, I saw you unmute. So did you also have an answer?
Yeah, just very quickly. I think a lot of these issues kind of roll into one another. So the rule of law isn't respected if we have a Supreme Court that's, purely ideological. And that hurts the court's reputation. So a lot of this stuff goes together. But I just wanted to focus on one thing, the evidence issue about the exclusion of evidence related to official conduct. That plus the combined effect of that plus the motive doesn't matter, I see as a really dangerous part of the opinion. Because that means you can shield so much simply by discussing it over a meeting with your cabinet, right? It's kind of like, it reminds me of Trump v. Hawaii, where motive didn't matter either. You can say all of this stuff, and so long as it's clean on the outside, then it's fine, right? And so I think that's a problem. Another thing I'm looking out for is what happens with the evidence if you're prosecuting someone who's not the president, another executive official? Will they be shielded because the conversation was with the president, right? And so even though that person doesn't have absolute immunity, the evidence can't be used because the conversation with the president and turning that over will cause the executive to implode.
That's a fascinating inquiry. Professor Wofford.
I can't find my hand raising thing, so it's just
That's
me
all right.
waving my hands. Somebody in the Q&A mentioned that they thought the court showed humility here by sort of pushing this back to the lower court, or they asked, did we think it was humility or did we think it was something more nefarious like delaying? I mean, I would add a third option that they just didn't want to do it, right? Because it's really hard to decide what is the line between official and unofficial. I mean, that's a really hard question. And so I think there was an avoidance of trying to craft what, again, I keep arguing they should have done, which is formulate a really reasonable test here. The other thing I wanted to say is I take the point is absolutely correct that Roberts, of course, and the other conservatives are very pro-executive power. And I see on one level, it makes total sense that they would want to give a lot of power to the executive. But the whole ambition to check ambition concept on which our government is created expects each branch to be self-interested. And what's really disturbing to me here is, as we pointed out, this opinion is going to be chopped to pieces by a lot of legal scholars. It's just being not well done legally. And what's really upsetting to me here is that, I mean, the court doesn't seem to be as interested in its own institutional legitimacy and its own primacy in the separation of power system as I would have expected them to be. And so it's hard for me to understand how their desire to give more power to the president caused them to overlook what might happen to their own political power and standing. And that undercutting that, if they're stepping away from that self-interest, we've got really big problems in our constitutional structure.
Yeah. Before we pivot back to Professor Levitt, this question of legitimacy, and it's an inquiry for everyone just to think about, right? How much has it actually already been there? I mean, we live in the only country, right, in the world that makes sentencing effectively a 13-year-old to die in prison, right? A juvenile imprisonment without parole is legal. Last week's decision with respect to Grants Pass with houseless folks who do not have the ability to find housing and who do seek it through, shelters, that is now legal to criminalize folks. And some might argue it's always been legal, right? But now it's just the law of the land. So I am really struggling personally with a lot of these questions of legitimacy from someone who is, I guess, a self-professed legal pessimist in some ways. But just to think about how much are we really grappling with legitimacy if the court has already been quite illegitimate in my view, right? Korematsu is another case. I think for folks who are at the most vulnerable and racialized have always questioned the legitimacy of our legal system and of our courts. Were there additional, Professor Levitt, you had one other thought.
So just on the broader legitimacy point, I think it also can't be lost. I also think this decision was not motivated, or it's not helpful to think of it as motivated by partisanship, as Lee mentioned. But it is not lost on anyone that 3 justices in the majority were appointed by a president who did not win the popular vote, that 5 justices in the majority were confirmed by senators who represented a minority of the American people, and that there were real serious senatorial procedural quirks, I'll say is the most forgiving way to put it, behind the elevation of at least 2 of the justices to the bench. And so I don't think it's lost on the American people the manner in which this particular court was constructed. Taking your point, Pilar, that the court as an institution has had a certain historical focus. This particular court was not ratified by a majority of the people, and I think that leads into how its decisions are likely to be seen. One tiny thing that Claire's comment made me think about, she mentioned it's really hard to tell unofficial acts from official acts on remand, and that is true, but I think only if you blind yourself to the particular facts of what happened in this case. And I'm going to be really interested to see how the courts on remand establish that question, right? In the abstract, is a president talking to a state official an official act or a not official act is a very different question than in the aftermath of the 2020 election, is a candidate for president trying to get a state official to find additional votes, an official act or non-official act. Right? Those are entirely different questions. And this court doesn't say what kind of veil the lower courts have to have in assessing the official or unofficial conduct, even before you get to motive, the unofficial or official nature of the conduct. I agree, it's hard, but the hardest question may be the level of generality at which the lower courts are going to have to deal with this.
Mm-hmm. We have one more question in 1 minute, so I'm hopeful that Professor Brewer, you might be able to come in and answer this question. Jeremy posed a fascinating, I think it's all around social media as well, right? Commander-in-Chief is the military, of the military is an official function of the president. If the president ordered the military to assassinate a political rival, the president may be immune from criminal prosecution. Military members have a duty to disobey illegal, unlawful, immoral orders. If it is not unlawful for the president to assassinate a political rival, is the president's order to carry out the assassination lawful?
I mean, there's a distinction, I mean, in our own minds between whether we think it's legal. If it's not prosecutable, then it's pretty, at least, I mean, conceivably it's impeachable, but it's not going to be punishable. The person who so ordered could refuse to carry it out, but others might well decide that in fact they will carry it out. And the way official acts are are described in this case to include, it actually includes protection for subordinates. So subordinates who agreed to do illegal things would be protected by this. The evidence related to it could not come out in a court of law. So if there's no remedy, there's no right, as I was thinking about that, Professor Levitt, as you were talking, which is the standard of the law. In other words, if there's no punishment, it just puts, I mean, I'm not saying there won't be really wonderful military leaders who might say, no, of course I can't drive the tanks into this, whatever, or I can't shoot half the members of Congress or whatever. But then the president could just fire them and find someone who would. So, and we've moved, I mean, although we know that Nixon did that partway and in the Friday Night Massacre or Saturday Night Massacre, and then we then were able to recover from that, right, and begin the whole proceedings and the investigations. it just would be harder to make any of that happen after this ruling. I guess I would love to hear from others.
I am noticing the time, very mindful of the fact that we have a second panel. I just want to thank everybody, our incredible speakers today, for your insight, your guidance, your questions. I think questions are very generative. If anyone can, the takeaway for me is so much is left unclear, so much is left unknown, including what does this mean more generally past Trump, right? What does this mean? Because the court very explicitly says at some point in its opinion that this is for everyone who is a member of the Oval Office in the future, right? So what are the engaging our imagination a little bit, what are the dangers moving forward that exist outside of Trump? Thank you so much to everyone. I'm now going to invite panelists from panel number 2 to turn on your cameras, panelists from panel number 1 to turn off your cameras, and introducing Professor Andy Siegel, who is a professor here at and Dean at Seattle University School of Law, to discuss the broader implications and what this means for the power of the presidency and our democracy moving forward.
I'd say most of the panelists have joined us already, so welcome to everybody. Thank you so much to Pilar and to the panelists in the last panel for an extraordinary conversation. I don't want to lose any momentum, so I think we should just jump right in. This panel is going to obviously have as a general focus that broader view that Pilar talked about, but the short term, medium term, and long term are merging in everybody's answers and analysis for obvious reasons. So I'm sure we'll hear a lot of the same themes. Our first speaker is Professor Robert Tsai. Professor Tsai is a professor of law and the Harry Elwood Warren Memorial Scholar at Boston University School of Law and an expert on so much in the constitutional arena. Welcome, Professor Tsai. Could you kick us off?
Sure. Can everybody hear me? Great. It's a pleasure to be with everybody. I'm going to try to do two things. First, I want to sort of provide some deeper context. I've been listening carefully to the first panel's wonderful commentary. And I also want to look ahead as well. And I want to do it by doing two things, putting this decision within the context of longstanding constitutional politics, and then also to talk a little bit about what we see in this opinion in terms of representing the variety of legal tools that are available to Supreme Court justices as they engage in decision-making as a form of constitutional politics. And I think once we do those two things, look at this decision within the context of constitutional politics, and we think about the tools that are available, this opinion really won't be all that surprising at all. Let me just start by first saying that I agree with others who have either said explicitly or otherwise that this is not an originalist ruling. It doesn't pretend to be. There's a little bit of history sprinkled in, but much of it is a more recent history. Instead, it's a kind of freewheeling national policy making by the Supreme Court of the United States, I think, for the good of the presidency. This is what 6 members of the court believe is the best way to protect the existing president and perhaps and all future presidents. And they've done it based on a malleable principle that doesn't explicitly appear, but everybody believes it appears, and that is the separation of power. So in other words, they're engaging in national policy making on top of and using this already malleable principle of separation of powers, where lots of different people have very different views about what it really means. And they're doing so shaped by what we know is reality on the ground, that is that a supermajority of the justices' experiences and their priors. And that is that they understand the modern presidency as something that must be protected from all manner of annoying activities, including annoying political forms of accountability, say from Congress or independent counsel, as well as legal proceedings of all sorts, including those by state and local prosecutors. This also brings in, I think, and it helps us understand some comments made earlier about why we don't really see a lot of evidence of negotiation with the three liberals that remain. And I agree with Professor Hutchinson. There is indication that there is some negotiation among the sort of within the conservative bloc. And this is a good example of their exercise of outsized judicial power to engage in this national lawmaking or national policy making. So they're negotiating amongst themselves, and there doesn't look like any real effort to gain the vote of someone like Kagan, who writes about the presidency, writes about the administrative state. They could have worked harder maybe to get her vote, but they don't need her vote. And so if anybody's surprised by the breadth of it, then I think this is what's going on. As others have mentioned, the text of the Constitution makes no mention of presidential immunity, and to the extent that there is any language that bears on what we're talking about, the impeachment clause explicitly contemplates criminal prosecution. And others have alluded to both the substantive dimensions of the decision and the evidentiary one. Okay, so what about constitutional politics then that I'm talking about? Here's the main point, and that is that lawyers who work for presidents, once they're picked to become justices of the Supreme Court, become justices who see the world from the perspective of presidents. This was alluded to earlier, I think, by Professor Kabarsky, but I think the point should be underlined even more strongly. You've got a number of members of the supermajority of conservatives who worked for a president in one form or another, either in the Reagan administration, Bush administration, or worked on the campaigns of presidents. And they all came away from those experiences extremely protective of the modern presidency. Think of it this way: the modern conservative conception of the presidency is sort of Hamilton on speed. The office must be unfettered as much as possible in order to get the job done, especially now that the president has a shorter amount of time to do work than perhaps as originally conceived. The Federal Society has long had in its sights curbing investigations against presidents of all sorts. In the past, the things that have annoyed conservative lawyers and jurists are independent counsels, special counsels, investigations by Congress. So it's no surprise that a majority of the justices are champing at the bit, since they've already been worried about those investigations, to do something more about the fear of prosecutors initiating criminal investigations and around the country. As we see in Chief Justice Roberts' opinion, they worry not only about possibly distorting the quality of presidential decisions, even with the prospect of criminal prosecution maybe years later, but I think a number of them would probably agree with this point, which is that they probably also are worried about the quality of people who might be willing to run for president if this possibility sort of hangs out there. One thing, there's other things you can find. I'll just give you one example, but this is from Kavanaugh before he was ever a judge, I think. He openly said, was the Nixon tapes case correctly decided? A unanimous decision. And he once said, and this is in paperwork that was made available during his confirmation hearings, that ruling, the Nixon tapes case ruling, quote, took away the power of the president to control information in the executive branch. Okay, so this is just one example, but I think this is a view that's largely shared. Anyone who remembers the Iran-Contra affair will remember Lawrence Walsh's investigation of the Reagan administration, and I think someone like Chief Justice Roberts, who did work in the administration, as a lawyer, will have been shaped by what they believe was too much of a roving investigation, which contemplated the possibility of at least some criminal charges. All right, second point, which is what do we learn when we think about this case in light of all the various tools that are available to the Supreme Court as a modern national policymakers? Well, we know that sometimes the Supreme Court issues substantive rulings, such as they did recently, to protect Trump and get him back on the ballot. So there they interpreted the 14th Amendment to prevent states from enforcing the insurrection clause without additional congressional action. We've seen over and over that sometimes they like to resort to procedural rulings, such as deciding how quickly certain kinds of legal claims by presidents can be addressed. They sometimes manipulate standing rules, such as in the recent Mifepristone case, or they'll sometimes use rules of deference. This is something we see in Justice Robert Jackson's famous steel seizure case, where he's kind of playing with different standards of deference. What do we have in this case? We have some principles articulated at a high level of abstraction. We've got no position taking on many specific things about how to apply those principles, kind of kicking the can down the road. But, and this is what's critical, clearly reserving the right to make those substantive judgments if the justices feel they need to later. There's one thing I want to also add on this point, which is that I see this missing in a lot of the media and early commentary about what this case's holding seems to be. You see it described as, okay, they've created this category of core powers there. The president is given absolute immunity. Then there are these other things that are official presidential actions, but not core. And there he's going to get some presumptive immunity. And my modification there is, I think they're not seeing the wiggle words that Chief Justice Roberts inserted in several places in the opinion. He said on that other category, what we'll call official conduct, but non-core, he said, we need not and do not decide whether that immunity for that category of things must be absolute or just presumptive. Later on, he says about that category of actions, at least presumptive immunity. To me, that suggests, and maybe this goes back to the earlier point about negotiating with conservatives to his right, who wanted to more clearly immunize certain things that Trump did. I think here we just still don't know whether we'll get a later ruling. Should Trump actually get convicted of some of these things, where they end up saying later, we substantively now say that some of those things that are non-core but official actions, he also deserves absolute immunity for those kinds of things. That brings, let me give you an illustration. I know I've been abstract myself. The First Amendment. This is kind of a surprising thing. There's several paragraphs in this opinion that refer to the First Amendment. You're like, well, what does the First Amendment have to do with anything? It reminds me of something that Chief Justice Roberts did in a different case, again involving President Trump. Professor Hutchinson alluded to this earlier, and that is the so-called Muslim ban case, Trump versus Hawaii. A couple of things here. One, in that case, the court also said something like this: once you identify core constitutional power by the president, then you don't inquire into the motivation of the president. This is a way of making certain kinds of evidence and certain forms of inquiry irrelevant, short-circuiting those forms of inquiry. Now, in the immunity case, it's not just about, say, equal protection challenges to presidential decision block people from coming into the country, but they've now theoretically broadened this approach to all core powers, not just those involving national security. We don't know where this will go in the future. Second, in both cases, we see a mention of the First Amendment as a way of what I think shoring up controversial policymaking. We see this in other cases where the justices try to exploit what they believe to be a broad consensus among everyday citizens regarding free speech. In this case, we see lengthy discussions about how a president speaks today to the country, and in Chief Justice Roberts' words, touches on nearly every aspect of American life, again reminiscent of his decision in Trump versus Hawaii. In the Muslim ban case, Trump had repeatedly said derogatory things about Muslim people and promised to block them from entering the United States. And there they said, that's not relevant anymore. We don't look at that kind of evidence. Here, we have potentially far-reaching obstacles created by making it impossible to introduce evidence of Trump's speeches that might bear on his state of mind, say, in whipping people up and pointing a crowd up at the Capitol, right? So here's a sloppiness point. We don't really know what the effect of all this stuff is. Does this discussion mean that Trump's efforts leaning on state officials to find him extra votes are to be insulated for an additional reason? In the section of the opinion that talks about that, it kind of says on the one hand this, on the other hand that, and kicks it down to the lower courts to decide. They do mention the take care clause, which is, I hope others talk about this, suggesting that, well, he argues that he is doing, he's leaning on these, he's making these inquiries because he's got a duty to take care that the, voting laws are enforced. Here's another possible thing that Chief Justice Roberts might be signaling towards, that there might be some justices who might be willing to insulate these conversations on a different ground, that is the First Amendment, right? You see some other evidence of this possibility where they go back, they kind of bend over backwards, saying that conversations between Trump and Pence ought to be protected. But these are very sloppy. There are a lot of allusions to this stuff, suggestions, no clear legal principles or rules. Brandenburg versus Ohio, which is clearly on point, is not mentioned. What does that mean? Does that mean a president is more protected than the average citizen when they incite crowds to do illegal things? We don't really know. Are they open to constitutionalizing what we might call the rhetorical presidency? If so, this is a purely 20th century phenomenon, and it would be incredibly non-originalist form of analysis to do so. All right, so let me just pause there, and I hope that provides some context, plenty of some of the things we've said, but also looks forward with some trepidation. Thanks.
Thank you so much for your insights, Professor Tsai. We're going to move along quickly to our next speaker, which is Professor Steve Vladeck of Georgetown University Law Center, a noted expert on the court, whose writings include his newsletter, One First, his best-selling book on the shadow docket, and a variety of academic articles. Steve?
Thanks, Andy. Thanks for having me. Thank you, everyone, for all the work that went into today's webinar. So I just want to make 3 points that are hopefully in the vein of moving the conversation forward from the first panel to the second along the lines of Roberts. The first, I want to say a bit about the Chief Justice, because I am really struck not just by the majority opinion he wrote in the Trump case, but about his sort of move this entire term. I mean, if you look at, the Chief Justice's majority opinion in Fisher, if you look at his, majority opinion in the Chevron cases, I would have thought going into this term that the interesting question was whether Justice Barrett would emerge as the median vote on the court. And I think it's now clear that she is the fourth vote. And that Chief Justice Roberts, for various reasons, has moved sharply away from his institutionalist tendencies, from his sort of willingness to try to work across the ideological spectrum, and has gone, not quite sort of full MAGA, but maybe half MAGA in these cases, which has some pretty significant long-term implications beyond the specific question of presidential immunity and presidential power. And I think, what's revealing about that to me is, I'm struck by the contrast, just as I was in the Colorado ballot disqualification case, where you have Justice Barrett writing a very, very short concurrence that just says, I don't know why we're deciding more than we had to here. It happened again in the Trump immunity case. And, the part of the majority opinion that I think is the most completely indefensible, the discussion of how official acts, for the most part, can't be used as evidence. Barrett's, I think, entirely right that that's one, wrong, two, not really part of the case. And I would even argue, if we had time to talk about the scope of the Supreme Court's appellate jurisdiction, three, not within the scope of the appeal. But that's a nerdy point. It's just the point is that Roberts went further than he had to, and went so far that he lost Barrett. And that's a really striking thing that's happened a couple of times this term, and that's going to have a lot of bigger doctrinal ramifications going forward. If Roberts is not going to be an institutionalist, query who is, and what that's going to mean if we get, for example, cases this fall on which the fate of the election turns. If we get, cases in, a, heaven forbid, second Trump administration, where the court really has to stand up for the rule of law. My concern, more than the specific impact of the Trump immunity ruling, is what it portends going forward. All right, so that brings me to point number 2, which is the court's credibility. Part of Roberts' institutionalism, I'd always thought, was a belief, and one that I think makes a lot of sense, that it's actually pretty important for the Supreme Court to have a modicum of credibility, even among its critics. that the ability of the Supreme Court to hand down unpopular decisions depends at least to some degree on, not unanimous, but at least broad public faith in the institution's fundamental legitimacy. And the basic idea that even if we don't agree with the justices' principles, we agree that they are principled. And I think what we saw this term was a number of decisions capped by the Trump immunity case, reflecting the existence of a majority that's not interested in the court's eroding credibility among a large and growing chunk of the population. I'm struck in this respect by not just the bottom line of the majority opinion in Fisher, but by the court's complete unwillingness to engage with the optics of its decision and how it was completely predictably and understandably portrayed on the far right as exoneration of the January 6th defendants and as vindication of the charges of political persecution. Anyone who cared about how the court is publicly perceived would have written a couple of paragraphs in that opinion to insulate against that concern. Roberts didn't. Right. And so what that says to me is that the Trump immunity decision is really going to become the most powerful, but just one symbol of this broader phenomenon where you're seeing increasingly a majority of the court and not just a particular block of justices who are not especially worried about how their opinions are perceived by those who disagree with the bottom line. All right. And that gets me to the last point, which is, to me, what I had thought was going to be the big theme going into this term, which is the increasing public worry about a court that is itself unaccountable. I realize it was 400 years ago, but the term started in the midst of all of these ethical kerfuffles about Thomas and Alito and yachts and jets and lions and tigers and bears. And what's striking about that is there was this remarkable moment in November where the court felt impelled to issue a code of conduct that I suspect most of us don't find very satisfying, but the mere move on the justices' part of feeling like they had to do that was a rather remarkable concession to me, that they thought they had to at least appear to be accountable. And ever since then, since November, I think we've seen symptom after symptom of justices who just don't believe that they are or ought to be accountable. Whether it's how Justice Alito responded to the stories about the upside down flags, whether it's in the opinions they've been writing, whether it's in the sort of the victim complex that you see in, for example, Alito's dissent in the EMTALA case, or in Roberts's majority opinion in the Trump case, where he talks about how quickly this case was rushed and it was sort of foisted upon the Supreme Court, which never had to grant cert, we should say. I had thought that maybe we would see the court turn toward trying to ward off a serious conversation about how we hold the court accountable. And to me, the irony of the Trump opinion, the net effect of which is to make it much harder to hold presidents accountable, is that I think it actually draws fresh light and the need for fresh scrutiny on just how unaccountable the court has become. I think this won't come as a great surprise to a lot of people, but we are dealing at this moment not with the first 6-3 conservative supermajority in the court's history. That's not new. Not with a court that's issuing unpopular opinions. That's not new, right? What is new and unique about the court we have is that this is a court that's not looking over its shoulder. It's a court that's not worried about Congress pushing back. It's a court that's not worried about the people who are going to disagree with it. It's a court that's not worried that anything it does or anything it holds is going to provoke the reactions that would actually sort of lead to the cutting back of its power. And I just, I think that's really unfortunate. I think it is a sort of self-sustaining delusion where the less the court is accountable, the more it will do things calling out for more accountability. And I'll just say, last and not least, I think it's a real failure on the part of President Biden, who's running for re-election on the ground that he's running against Donald Trump. And I think it's increasingly clear that he's also running against the Supreme Court. The Supreme Court has been a far greater obstacle to the domestic policy achievements of the Biden administration than Donald Trump has been. The Supreme Court is doing far more than Donald Trump has done to try to make it harder to hold Trump accountable. And so, the notion that the Supreme Court is just this unfortunate pest that's getting in the way of the Biden administration, I think is something that is really going to, undervalue how much influence the court is wielding and how much, again, just to get back to the broader theme, a world in which the court was more accountable, a world in which the court felt more accountable, and a world in which we did more to hold the court accountable would be a world in which it would be harder for the court to issue rulings like the one it issued on Monday. So thanks very much, and I look forward to what everyone else has to say.
Thank you so much, Steve, for fascinating comments. And I don't want to lose these themes. I know that a lot of our panelists on this panel have specific things that they're going to speak to, but just remembering for our conversation later and for our questions, themes about, is it possible, and if so, to push back against this court? And if we don't push back against this court, what space is left for progressive public policy for this administration in the next term or future administrations, given the ways in which the court is squeezing in so many different places? But for our next presentation, the speaker is Rachel Lopez, who is recently moved to Temple University Beasley School of Law, an expert on a variety of things related to justice, in particular here speaking, I think, on upcoming work related to transitional justice and more theoretical work about the role of criminal prosecution in transitional justice and how we hold our leaders who fail us accountable. Rachel?
Thank you so much. It's such a pleasure to be here. And I again want to thank the organizers for organizing this tremendous webinar. Of course, I've been invited here to share my perspective from the perspective of a comparativist and international legal scholar. And so I'm going to focus my remarks on insights that this particular perspective yields, focusing on two main questions. The first being judging from examples worldwide of countries that have chosen to prosecute former heads of state, what are the possible long-term effects that this might have on our democracy here in the US? And secondly, looking at how does this ruling square with our country's obligations under international law? And I'm going to start with that second question. And I, don't mean to be alarmist here, but I think that there's a strong case to be made that this decision contravenes our obligations under international law to prosecute and punish the most serious violations of international humanitarian law and international human rights law. And I'll just give one example, though I know that there are certainly others, which is the Genocide Convention, which is binding on our government. The US has signed and ratified this international treaty. And it requires governments to punish genocidal acts. And this is reading from the treaty itself, regardless of whether that person is a constitutionally responsible ruler or a public official. So the instrument itself explicitly states that. And under the current ruling, if the president directs the military to engage in genocidal acts with the intent to erase a racial or ethnic group from the map, she has a fair shot at absolute immunity if she is acting within her core powers as a commander-in-chief of the armed forces. And I have to say that this is particularly so because the court has made it explicit that is not permitting any inquiry into motive, which is essential to any genocidal claim. So in other words, claims of genocide turn on specific intent to destroy in whole and part a particular racial, national, or ethnic group. So this, in a way, is to some extent similar to how Justice Barrett described bribery, and that it would not be possible to prosecute genocide without references to acts that fall under President's Article 2 powers. Now, I have to say that certainly it's not unheard of for other countries to provide amnesties and immunity to heads of state, but they're typically part of a political compromise. So, and this was the case, of course, with Ford's pardon of Nixon. So, for example, for the amnesty laws in Colombia, they were part of a political compromise to maintain peace. In South Africa, they were in exchange for truth, in exchange for admission of acts. And my view is that such compromises can actually be helpful to serve other governance goals, such as reconciliation or transparency. But I would place what the court did here in a much different category. By providing blanket immunity and taking intent off the table, the Supreme Court has not only made our country a global outlier with respects to the punishment of atrocities, but it has done so to make one person in our history a man, and typically a white man. It's allowing that man to engage in the most horrific acts without any imaginable consequence. And for those of you who know my broader work, they know that I work with many formerly and currently incarcerated activists. And for them, this decision confirms what they've known all along about our criminal legal system. That is, that it immunizes those with power and privilege while throwing the book at others. And so just to throw back to Professor Hernandez Escontria's comment, under the laws of this country, it would be possible for one man, if he is the president, to commit genocide or order genocide without consequence, and another to be sentenced to die in prison for death that he did not intend. And my fear is that this will only further erode, the average person's confidence in our government at a time when, according to data, it's already at a historic low. And while, as a general matter, I favor moving away from this country's carceral default, doing so only for the powerful is only further proof of injustice masquerading in the cloak of law. So that then brings me to my second question, which is, what are the long-term effects of this decision on democracy, judging from examples worldwide? And I will say here, I'm a little bit more circumspect with regard to that topic, which touches on an aspect of my research. And so I will note that so much of the commentary, both prior to this decision, during oral argument, and in the aftermath, and even in the decision itself, are centered on this question of the long-term effect on democracy. And in my view, this rhetoric has been far too dire than the evidence suggests. So, for example, Trump has said, right, that this decision is a big win in quotations for democracy, while Justice Sotomayor is predicting dire consequences for our democracy. And I think both of these statements overstate what criminal punishment can accomplish. And judging from empirical evidence of the prosecutions of heads of states worldwide, neither are completely right. And so here I'm going to touch on a bit of the research I've been doing with a political scientist at the University of Toronto, looking and using the most complete database on prosecutions of heads of state worldwide. And we found 4, I think, significant findings about the democratic effect of criminal punishment of heads of state. So first, trials do not typically catalyze or endanger some of our democratic mainstays. So they do not endanger free and fair elections or judicial independence, but they are associated with certain pro-democratic behaviors like increased political engagement in civil society. And relatedly, trial proceedings themselves do not catalyze pro-democratic protests or demonstrations, but convictions actually do. So in line with these findings, I can't say, as President Trump would suggest, that this is a big win for democracy. Rather, the effects are more mixed. And likewise, our most sort of controversial and consequential finding is that both prosecutions and convictions, increase political polarization, particularly of heads of state. And they actually tend to catalyze anti-system movement activity, so people that seek to undermine the rule of law. So despite Sotomayor's warnings, criminal prosecutions can also pose unique risks to our democracy. For the rest of my findings, you'll have to look at my research posted on SSRN, but I also want to conclude with a note of caution, which is, it is true that context matters. And while these empirical findings hold over a wide array of nations that have chosen to prosecute heads of states, we have to, of course, look at the specific context here in the United States. And in contrast to what Professor Levitt's point was, that convictions don't matter, the research actually shows the contrary. So numerous polls have shown, both before the conviction in New York and after, that if former President Trump is convicted and sentenced, around 6% of voters in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin would switch their votes to Biden. And that is actually enough to be consequential in this election. So And I think it's important to note, right, as Professor Kowarski did, is that this decision, because of the remand and the difficulty of moving ahead, will inevitably delay further prosecutions of Trump. And in this way, will have an immediate and direct effect on our democracy. So thank you so much for inviting me to be part of this rich discussion, and I look forward to engaging with others as well.
Thank you so much for that contribution and for that international and theoretical perspective. We're going to move on again, just in the interest of getting everybody to speak at least once before we open up dialogue, but plenty of questions for everybody. Our next speaker is Andy Wright, who is currently a partner at the K&L Gates law firm. In prior lives, Andy was a legal academic, a senior lawyer for Congress, a senior lawyer in the executive branch, and the director of legal policy for the Biden-Harris presidential transition. So he's worn a lot of hats and has a lot of different perspectives that'll probably influence his remarks today. Andy?
Thanks so much, Andy, and thanks to you and your colleagues for putting this on, and my co-panelists for sharing their views. It's a pleasure to be here. I wanted to talk a little bit about the political branches and some of their institutional incentives and leverage, I think, coming out of this opinion to try and take it into this next phase. Some of this will echo, I think, what Professor Levitt and Professor Tsai have said previously, hopefully building on to it. The first thing I'll just say, confessing an unpopular opinion probably for this panel, which is the executive branch lawyer in me, also having been one once, is sympathetic to the energy in the executive arguments and the fact that there have been the politics of sort of personal destruction and use of criminality to try to disqualify candidates when it really should be a relative choice between competing visions for the country. And I think that's been an increased problem in our system. That isn't trying to exonerate President Trump's conduct or make a judgment about the validity of those cases. But I do think that that's been a symptom of our polarization and is not a good thing. But that said, and I'll also say that investigations do have an effect on the performance of duties in the executive branch. I mean, I had periods where we were really only using whiteboards and telephone calls because there were subpoenas coming in every day asking for what did you do yesterday? And I don't think that's a good way to run a government. That said, I think presumptive immunity or qualified executive privilege are ample to cover those issues, and you don't need absolute immunities. I think this tilts things drastically in the wrong direction. It's very helpful to have at least the shadow of criminal prosecution as something along with congressional oversight that keeps you looking over your shoulder and making sure that you have adequate justification for your use of official power in the executive branch from the president on down. Now, I understand that subordinate executive branch officials may still have that risk, but I think that's a helpful thing in the overall context of performance of our duties and keeping checks on abuse of power. So that's unfortunate. One point I wanted to make that I think is practical, than just maybe a nerdy point to me, but it will be interesting to see how the lower courts sort out these official versus personal or political acts that are not official. That's a complicated issue for presidents. From scheduling to having a mill aid with the nuclear codes at every event to political campaigning to personal, weddings and other things that they attend in their lives. Trying to piece that together is difficult, but there are models that do it right now. So it'll be interesting to see what the courts look to. But, for example, when the president travels, the advanced staff keeps hard times for how much time they spend at each rally so that they can divvy up the Air Force One or Air Force Two costs to their political and official accounts. There's, Hatch Act precedent, there's equipment usage, et cetera. So it'll be interesting to just see how they sort that in addition to the constitutional considerations and functional analysis. Wanted to talk for a second about DOJ independence, which seems to be swept away on page 20 rather blithely. I had a very different take on the idea that it's important to insulate federal prosecutions of particular targets from interference by the executive, including the president. I think that is not only a norm and not only something that's been subject to numerous memos from White House counsel to White House staff over the years, but also is part of the Take Care Clause obligation and the oath of office to keep some level of even-handed administration of justice as a consideration of that role. I encourage you all to take a look at that, because the court is very clearly giving a green light to a president to just pick up the phone to the attorney general and say, I'd like you to convene a grand jury to go after X person, and that would be just fine and probably immunized absolutely under this ruling. I also note that has an ancillary effect. There's been a longstanding dispute between Congress and the executive branch over criminal referrals of contempt of Congress. The statute in Congress says that the U.S. Attorney for the District of Columbia shall convene a grand jury when Congress refers someone for criminal contempt prosecutions, and OLC and the executive branch has resisted that interpretation, suggesting that the executive branch has ultimate authority to decide who it prosecutes. The executive branch has had the power to determine the outcome in that dispute, but this case seems to suggest that the Supreme Court would side with the executive branch conclusively on that question, again, which I think saps some of the arguments for and strength of congressional oversight going forward. The last thing on that vein that I wanted to turn to are, what are the remedies? So if we can't use criminal prosecution for presidential excesses that relate to official conduct, how about those political remedies, starting with impeachment, but also looking at the election that Professor Levitt discussed? And so the first thing I'll just note is the connection between the two. Bob Bauer, in his new book, The Unraveling, talks about how 3 of the 4 impeachment inquiries since Watergate up until the Biden administration focused on efforts to cheat in an election. So the conduct at issue in 3 out of 4 was trying to use official power or use criminal acts to try and gain an advantage in an election. So clearly part of the check associated with impeachment, I think, is bound up with the fairness of elections and the efficacy of an electoral remedy. So that's one point that I think is important to think about as we go forward. The second point, and this is where I'll finish, is I think this opinion undermines impeachment itself. And here's how. The treason, bribery, or high crimes and misdemeanors is the standard that the constitutional framers put in the Constitution for us to fight about whether or not to remove the president and other executive branch officials. And that debate has had a long and tortured history, but it ranges from Gerald Ford saying an impeachable offense is anything that the House gets a majority to vote on, to the hyper legalistic, is there a criminal code violation that's been violated that could be prosecutable that would justify this? Or is there an originalist kind of model of a crime at the time of the founding that would be recognizable as an impeachable offense? I've always had a view that I think is somewhere in between, which is that it's an invitation to fight politically to justify why some conduct is a high crime or misdemeanor. In a political sense, they could have just said you had enough votes to remove somebody, right? But they didn't. So that's not the Gerald Ford model. There's some sort of fight we have to have politically to legitimize the removal of a president following an election. And here, I think that the immunity for criminal acts is going to create arguments that didn't exist before, to suggest that because there's immunity for official acts, therefore it can't qualify as a high crime or misdemeanor, and therefore it's going to undermine the ability to build the consensus in Congress to use that standard, which is already a steep climb with the supermajority in the Senate for conviction. So I think both remedies, in one sense, were a little bit, on the political side, were a little bit undermined by this opinion. I think that's a significant concern of mine as we go forward. So I'll stop there and look forward to the continued discussion.
Thank you so much, Andy. And Andy's remarks are in line with the other remarks from from this panel and towards the end of the last panel, I think one thing we're struggling with collectively here, and I definitely want to hear people's thoughts on this as we move forward, is first of all, was our system ever really well defined or designed to prevent putative dictators, to prevent real attempts at executive aggrandizement, dangerous anti-democratic attempts at executive aggrandizement? And the second and bigger question is, given what the Supreme Court has done to some of our crucial tools in a variety of cases, most notably this one, how desperate is the situation? How good are the tools we have left? How functional are they? Can we make them work in appropriate circumstances? So I definitely want to keep that kind of stuff on the front burner. The next speaker, we have 3 more scheduled, but one is not here. So I'm guessing there'll be 2 more speakers on this panel. Our next speaker is Professor Jeremiah Chin, my former colleague, in the middle of a transition from Seattle University to the University of Washington. Another outstanding constitutional law scholar with interesting expertise to bring to bear on this case. So Jeremiah?
Thank you, Andy, and thank you to everybody on the panel, and of course, Seattle U for having me and introducing this, again, very important topic. I think I want to make a lot of connections to stuff that folks have already talked about, particularly in terms of the majority opinion and what the framework really is, how and whose perspective gets analyzed during that opinion. And I think the way the court really frames it at times feels like it's expanding the power of the executive under Article 1, right? But it runs into this really large aggregation and disaggregation problem where it's talking about the executive at times broadly, but the president at times specifically. And it seems very focused on the office of the president themselves rather than the idea of the executive branch, which they've curbed in a lot of opinions dealing with the administrative state over the last term, but yet the office of the president seems to be immune from any kind of criticism. Instead, the court follows a framework that I think Professor Tsai brought up really well, that it started in Trump versus Hawaii, when it really gave huge deference to the executive branch to kind of say and do whatever the executive branch was thought was legitimate or justifiable, and then the court would seek out a constitutional reason afterwards. So like I said, at first blush, this seems like a big executive power question, but to me, this case really comes down to the power of the courts, because I think, as Justice Jackson points out at the end of her dissenting opinion, that this really makes the courts the arbiter of everything. Is it an official act or a non-official act? Well, a court has to decide that. So rather than, I know that there was a question in the first panel about humility or deference to a trial court. I don't think that's humility or deference to a trial court at all, but rather an empowerment of the Supreme Court itself, because now they are the ultimate arbiter of what is or is not presidential and what falls within the scope of the authority of the president itself, which is the language that the court used in Trump versus Hawaii when it said that Trump's anti-Muslim sentiments that he tweeted out, said repeatedly, verbally, and the court even acknowledged as anti-Muslim sentiments, were still immunized because there was a constitutional power to create a facially neutral law. And that degree of facial neutrality, I think, creates what's a big pretextual power of the executive, where as long as the executive branch creates some kind of pretextual reason for taking any sort of action, the court has given itself a broad discretion to legitimize anything the executive wants to do. And I think Justice Sotomayor gets up to a lot of that in her dissenting opinion, but I think what she doesn't make as explicit is the role of the court in facilitating that process, not just in this opinion, but in all future opinions. The court has made itself the go-between for any kind of executive action that would aggrandize people, that would harm the general public, because as long as it's, quote, the view of the president, the public is served, the court can sign off on it. And that was another really important and critical piece of the way that Roberts frames the opinion, is that not only is the court the arbiter of whether an act is itself official or not, but the president is the arbiter of what's best for the people. So this really patronizing, patriarchal kind of view of the executive office as the steward of our entire nation and determining what is best for the public rather than as a representative, to me goes against the, the framing of the executive office as directly elected. If we're going to follow the illusion that the people elect the president to enact some sort of agenda, then why are we all of a sudden switching gears to say the president knows what's best? And it's the goal of and role of the courts to defer to what Roberts refers to on page 27 as the president's view of the public good, right? Not even something they were elected to do, not even something that is necessary to the public, but rather whatever the president's view of the public good is, which in the case of Trump, in cases like Trump versus Hawaii, is the exclusion of Muslim people, right? So that kind of hostile sentiment not only opens us up to an immunity locally, but I really appreciate Professor Lopez's comments in thinking about the international aspect of this, because I think the court is very mindful of it. To put it in modern terms, I feel like the court is very subtweety with that, and like indirectly referring to the ways in which our executive and executives nationwide have been implicated in genocide. And the fact that we see the International Criminal Court pursuing charges against different entities at this current present time, I think the court is very mindful of that. And I think the court is saying is that we are describing and finding our legitimacy inherently in ourselves, rather than an extrinsic kind of reciprocal recognition that we've seen historically with conceptions of sovereignty in the international arena. The United States originally got its sovereignty from recognition of nations of Europe and the recognition of the indigenous nations that pre-existed the United States, that made the United States a viable political actor nationwide, internationally. Now the Supreme Court is kind of flipping the script, flipping the delicate balance that Marshall tried to lay down in his initial framings, and instead saying, no, the judiciary has inherent legitimacy. Going back to some of the other wonderful comments on this panel, that rather than finding the legitimacy of the court in the people, the court is finding the legitimacy as inherent in and of itself. It doesn't need any other kind of ratification from the people. It doesn't need public opinion. It doesn't matter what people think about it. The court will do what it wants, which is really interesting coming from a justice, well, coming from some of the justices, especially ones who public opinion seems to matter a lot. Like if somebody else flies a flag in your neighborhood that you don't particularly like, then you're perfectly justified in doing all kinds of ridiculous things in response, right? So that kind of internal versus external validation element really is hammered home throughout the opinion. And is so fascinating in allowing this kind of pretextual references to the president and the executive branch writ large, even when quoting, historical jurisprudence with the idea that the Constitution deals with substance, not shadows, right? When in fact, you're allowing the president to indirectly attack or do whatever they want, as long as there's a pretext of some official action, which then the court gets to determine some degree of absolute immunity, right? The second and final big thing I want to think about is the idea of the chilling effect, going back to the First Amendment point that, again, Professor Tsai raised so well at the very beginning. Going back to Professor Levitt in the first panel, this is definitely an inversion that the court does of what we would usually consider of chilling effect, or the way that chilling effect is conventionally used. Here, they're looking at the chilling effect in preventing an actor from following the law, rather than usually when we think about chilling effects, we talk about the law chilling action from happening, and thus the law itself must be overturned. Rather than analyzing the general, neutrally applicable criminal statutes that the court is, that is being applied to President Trump in this case, rather than analyzing whether or not those laws are justified and thinking about the carceral implications of that, like Professor Lopez mentioned, instead the court is saying, well, the president is more important than the law itself. Right? We don't want to impede the president with any kind of thing like criminal codes or criminal law or moral duties and obligations that we impose on ordinary human beings, but rather this kind of insulates the president from any of those considerations on a more radical level than I think we've ever seen at the Supreme Court. Right? It really reminds me, and Professor Tsai starting us out is maybe apropos of this with his recent book on Stephen Bright, of Justice Brennan's dissent in McCleskey versus Kemp, when he said the court is really afraid of too much justice. Right? Here, the court has sacrificed the system of the criminal justice system in favor of preserving the institution of the presidency and the court itself by binding the two together in kind of this future interaction of a pretextual presidency and a court that gets to sign off and determine what acts get immunity and what acts don't.
Thank you, Professor Chin. Our last panelist for the day is Professor Jed Sugarman, last but not least, of course, from Boston University School of Law. He's one of the leading legal historians on a variety of issues, including most notably here, the early history of executive power and executive power at the American founding, author of a variety of articles and book in progress on these very issues. I know he's got some strong, sometimes idiosyncratic opinions, and I want to hear what he has to say.
Great. Well, thank you so much, Andrew. And Andrew's someone I looked up to way back in our undergraduate days. And so some of my interests in legal history started when you were a few years ahead of me. And so thank you for also pioneering these issues. And thank you for having me. This has been an extraordinary set of commentaries. And I'm really honored to participate and be in this role of, in some ways summarizing, but I'm going to have some idiosyncratic views in some ways. And I'm going to pick up on some points and make sure some points that haven't been made are clear. So one point I want to pick up on is some people have talked about the timing. I want to reiterate that Jack Smith saw this coming. I mean, Jack Smith saw this problem. And in December of 2023, he asked for to leap the DC Circuit, not because he was scared of the DC Circuit. He knew the DC Circuit was going to do something more or less of what it did. He was concerned about exactly this happening. So what he did in December was ask for this to have an appeal from the trial court to the Supreme Court, and the Supreme Court declined. And at the time, the only way one way to understand why the Supreme Court declined is that they were trying to do things in regular order and appear non-political. The background understanding of what Jack Smith was doing, though he didn't say so, was that he wanted to make sure this trial would happen before the election. And when the Supreme Court, the irony here is to pretend like things were regular, it has behaved in dramatically irregular ways. If the Supreme Court had such idiosyncratic and frankly extreme right-wing views about presidential power, it had a duty to do so and say something when it knew. And it is, I think, one of the most damaging moments in the Supreme Court's history that it did what it did here. That knowing what we know now, it had a duty to the Republic to grant cert in December of 2013, to expedite that case and issue this dramatically unprecedented meaning that without any tethering to text, history, tradition, or precedent, and clarify that then. This is a crisis of the Supreme Court's legitimacy beyond what the Roberts Court has done. I think it deepens this illegitimacy problem. So that's one problem, and I can't and also the Supreme Court should not have, once it didn't grant cert in that extraordinary kind of appeal from Jack Smith, it should have let the DC Circuit stand, even though it disagreed with it. We now know the problem of the lightning docket. This is a term that's different from the shadow docket, but I think this is Dan Epps' term. The Supreme Court has made repeated gross errors in expediting review in sloppy ways. I cannot tell you as an historian how dramatic the errors and assumptions and embarrassments are page by page in the majority opinion. And I say this as an originalist, right? I care about the history and text and original public meaning of the Constitution. I think that when the meaning is clear, it trumps other, no pun intended, other kinds of methods. But here, as an originalist, I'm embarrassed because this is an embarrassment of what originalism is in practice. It is simply cherry picking some convenient quotes out of context. I strongly agree with what Holly Brewer was saying earlier, and what Smita Ghosh was also saying earlier. This is not, and what Robert Tsai was saying earlier. Okay, but on the flip side, I also want to confirm what Andy Wright was saying. We live in an era of lock her up, lock him up. I want to note also confirming what Robert Tsai said about the relationship between these justices and the executive branch. It is of note that Brett Kavanaugh and Amy Coney Barrett served during the Starr investigation. And Kenneth Starr is a cautionary tale, or a cautionary male, if you will, about the misuse of prosecutorial power. Guess what else is a misuse of prosecutorial power? The Manhattan DA using federal law in unprecedented ways. There has never been a state prosecutor that's used federal election law and FECA in a state court. There was no record of that kind of prosecution. The use of New York state law of 17152, that was the turning point in the Manhattan DA's prosecution. So was an unprecedented use of that New York state law for a federal office. So it was unprecedented both ways. I think, look, I personally think that Donald Trump violated federal law, but that was a decision that the DOJ had to make, and they decided not to make it. Each side has ample reason to worry about, and I hate to overuse this phrase because it is weaponized. The word weaponized has been weaponized, let's say. But we live in an era of lock him up and lock her up and the abuse of prosecutorial power. And I strongly agree with what some of the sentiments of earlier speakers, including Rachel Lopez, made this point as well, which is it is hard to talk about, the importance of prosecution when prosecution is one of the great crises of mass incarceration in our society today. And so I think the left has to do some serious soul, and I say this as a left originalist. We have to do some soul searching about when we like prosecution and when we don't, right? I think we are doing a lot of complaining today about, we need to limit the dangers of limiting prosecution. I think we've got, frankly, a crisis of hypocrisy on both sides. The left is very eager to criticize prosecution, and rightly so. Mass incarceration is a bigger crisis than whether or not a president gets prosecuted after leaving office, right? People's daily lives are affected more dramatically by the gross abuse of unchecked prosecutorial power on the war on drugs and the war on people of color. And so I just want to take a step back and say, I have a hard time complaining about immunity, right? If we're not willing to talk about the abuses of elected partisan prosecutors in places where people of color live, and white people elect those prosecutors, and those prosecutors then do their job by incarcerating people of color. Now, it just so happens if we can't have that conversation, then it's hard to talk about, the larger big picture limits on prosecution. So I just want to put that out there. Like, if we're worried about the politics of prosecutors, let's not just look at Ken Starr. Let's also look at Alvin Bragg, and let's look at prosecutors all over this country for the last century and the damage that they've inflicted on so many families that don't have all these rich Republican lawyers to represent them. And the last point I want to make is about originalism, because this is an embarrassment. As an originalist, I say, like, maybe I'm ready to give up the ghost. And by the ghost, I mean like the ghost of Madison, the ghost of Hamilton, and the ghost of, all these ghosts that keep haunting us. I'm ready to give up the ghost if this is what originalism looks like, if it is a patina and a facade of legitimacy. So just to highlight the point here, what is a core executive power? I don't know. That is not an originalist concept. But let me also tell you how it gets applied in this opinion. There are two, quote, core exclusive executive powers named, and neither is, it feels like this is like the Holy Roman Empire. It's neither holy nor Roman nor an empire. These are not core, preclusive, exclusive executive powers. One was the power to supervise the DOJ. Andy Wright is completely right. That was no pun intended there. Other puns are intended. But the idea, when the DOJ was founded, this is an article I wrote 10 years ago. The DOJ was founded consistent with the founding and with the 1860s. It was founded in 1870 to be independent of the president and to be independent of politics. This opinion disregards the founding and Reconstruction on those values. And this idea of removal being a core executive power, this concept, this historical assumption has been debunked by a dozen different historians, both 30 years ago, 100 years ago, and there's a whole cadre of us over the last 5 years that have completely demolished the idea that removal was an executive power. It has been propped up by, frankly, the rampant misuse and misrepresentation of historical sources by a set of unitary executive theorists who cannot back up their claims with actual citations to actual pages of actual documents. So let me pause and, we can dig into this, but if removal, which is not textual and not originalist, is a core executive power, then surely the commander-in-chief power must be. And if the commander, so if people are saying surely the rhetoric of Sotomayor about assassinations is an extreme kind of rhetoric and is untethered, no, she's actually quite right? If assassinating someone is tethered to the commander-in-chief clause, that is far more based on text and original public meaning than the myth of removal. So what the Supreme Court here has done is Sotomayor's called it out, and they didn't have the courage to acknowledge it, which is the commander-in-chief power is subject to absolute immunity. They just weren't willing to admit it. That's the only way to read their opinion. And it's embarrassing because that came out in oral argument as no one could possibly imagine an opinion granting absolute immunity to sending SEAL Team 6 in to assassinate a political rival. I don't know how the majority opinion even acknowledges that problem. It just simply allows it to be true. And Sotomayor simply has the temerity to name it. And finally, the unitary executive theory, why? If presidents kind of are going to rotate back and forth, why is the Roberts Court so committed to the unitary executive theory, or something that Jody Short at the University of California, San Francisco, and I have called presidential superiority? Noah Rosenblum, Ash Ahmed, and Lev Menand are three legal scholars that have named one theory. I agree with this. It is that they believe that both Republican and Democratic presidents are going to be more deregulatory than, quote, the deep state. And so this is pro-corporate. There's a pro-corporate, pro-capitalist deregulatory agenda behind maximizing presidential power over quote unquote bureaucrats, or like, how about like public servant experts who actually care about making sure the economy works? Okay. Or how about expertise? So that's one theory. But the last thing I want to talk about here is the culture war. There's an assumption by the Roberts Court that presidents, whether Republican or Democratic, are going to be more tethered to the median voter of Wisconsin or the median voter of Pennsylvania, which is a cultural conservative voter, than the secularist, globalist, deep state expert that cares about LGBT rights or cares about civil rights and integration. And the assumption here is that the white supremacists of America have more to say about who's president than they do about who's in the DOJ Civil Rights Division or who cares about the Department of Education. And so there is a culture war. And in fact, Scalia said it best in the original German. There's a Kulturkampf. And what the unitary executive is fundamentally about is 5 or 6 justices who are fighting a Kulturkampf against modernity and against people of color and against LGBTQ rights. And the way to do that is maximizing presidential power over experts who are educated and actually care about committing their lives to public service. That's the Heritage Foundation's Project 2025. That's Project F, Schedule F. And that's what's coming with the Trump administration that looks right now more likely than not to be in our future in 2025.
Thank you for what would
I'll
have
end
served,
on that note.
thank you for what would have served as a wonderful wrap up to everybody's comments. But I lied. Ilya Snowman has joined us, our last panelist from the UK. We thank him from popping on a very different time schedule to share his views. Panels have a life of their own. The last one, there was plenty of time for interaction and questions. This one, each of you had such diverse and interesting insights that we've used up the bulk of our time. So I'm going to take everybody's indulgence to stay with us an extra few minutes past their 12:45 scheduled end time and let Ilya share his thoughts on the decision. Thank you so much for joining us, Ilya.
Thank you for having me, and thank you to University of Seattle for organizing this event. As already mentioned, I'm coming to you from London and also dealing with a time zone transition, so I apologize in advance if I'm even more incoherent than might have otherwise been the case. But I'd like to talk here about 3 points. One is the role of originalism and textualism as opposed to functionalism or practical considerations in yesterday's decision. The second is the lack of clarity in many of the concepts and precepts that the majority puts forward. And then finally, some implications of that for the future. So if you want to sort of sum up the role of originalism in the majority opinion here, it is that for the most part, it just isn't there. There is remarkably little citation to either text or original meaning. It's all extrapolation from precedent and also putting forward functional considerations, especially the idea already mentioned by many panelists that we don't want presidents to be unduly hobbled by investigations or prosecutions that would, as the court says, prevent the executive from engaging in, quote, bold and unhesitating action of the kind that we might want the president to do. So it's perhaps understandable that Chief Justice Roberts, who has never said that he's a consistent originalist, might be this way, but several of the other justices in majority do have strong originalist commitments, and yet they signed on to this, and that's pretty striking. Also pretty striking is the role of originalism in a dissenting opinion by Justice Sotomayor, who of course is not an originalist, but nonetheless, she does much more in the way of originalist analysis here than the majority does. I think she makes many good points, and on balance, I think it is correct that there's no good originalist basis or textualist basis for the kind of seemingly very broad immunity that the majority gives us here, and I think there's many dangers in it, both some which she points out, some which have been pointed out by panelists here. But I also can't help but notice the role reversal between the majority and a dissent between this case and the Loper-Bright reversal of Chevron just a few days ago, where there it was the conservative majority which says, well, there's a textual and legal formalist and originalist reason why it should be courts, not the executive branch, that should be tasked with interpreting the laws, and there's problems there. And on the other hand, is the dissent, which says, well, we need to let the experts do their thing and rule benevolently and wisely. They don't quite say that we need the experts and the executive generally to engage in bold and unhesitating action, but the ethos is fairly similar. And I say that because I'm one of the small number of people who both approves of the Loper-Bright decision and disapproves of the one yesterday. And it's for the same reason in both cases. It's important that the executive branch live within constitutional originalist constraints and that they not be allowed to engage in a variety of abuses of power, to which I think both the president and also various administrative agencies, which is worth recalling, are generally headed by officials appointed by the president, that they too can engage in those sorts of abuses. But in both the majority and the dissenters, and perhaps many of us in the legal community generally, it would be worth it for us to take a more consistent line on when exactly originalist and formalist considerations should be allowed to trump. Yes, the pun is intended here. The idea that we need more energy in the executive or more deference to experts and the like. And I think we should consistently say that we should keep both the executive and the experts appointed by him on a constitutional leash. As Jefferson said, let us hear no more of confidence in man, but bind him down with the chains of the Constitution. And I'm all for applying the chains. But a lot of the time, different wings of the court, they're inconsistent as to when they're willing to do the chaining and when they say no, like the chaining interferes with expertise or with boldness or energy in the executive or other things that are not actually found in the text and original meaning of the Constitution, but may be convenient for achieving various kinds of policy objectives. There are a couple of exceptions to neglect of originalism by the majority. One is a discussion near the end where they reject what they say is Trump's even broader claim of immunity based on the idea that he can't be prosecuted unless he's impeached first. There they make some good textual points as to why that doesn't make sense, because in that issue, the text is actually on their side. Justice Thomas also has a lot of originalist analysis in his concurrence, where he argues that Jack Smith wasn't properly and constitutionally appointed, but that, of course, was not the issue of immunity that the court was centrally supposed to be addressing in this case. So on balance, it was not a great day for originalism, at least for the majority. One would think with an opinion that's functionalist and that tries to foreground practical considerations, that they would give us clear standards for how these issues should work going forward. But that is exactly what they do not do. So even from a functionalist standpoint, this, in opinion, has a lot of problems. There are several very unclear parts here. One big one is, what is a core power as opposed to an official act that's outside the core? The majority gives a couple of examples of what is a core power, but doesn't give us any general means of separating out core powers from non-core ones. So it's a mess on that front. Second, there is this jaw-dropping ambiguity, at least of whether the immunity for other official acts, those outside the core, whether it is absolute or just presumptive. The majority says we don't need to decide that. Seems to me if you're going to give clear guidance to lower court, including about this case, you do need to decide that, but they don't. And if it is going to be presumptive, another issue on which things are not clear is what would be enough to overcome the presumption. Seems like that's kind of an important point that would be useful for the lower court to know as they try to delve into the case, but the Supreme Court doesn't tell us. Now, some of this ambiguity could perhaps be good, depending on how things shake out, because one can imagine if all of these ambiguities are resolved in favor of a narrower range of immunity as opposed to a broad one, then the negative impact of the decision would be less than otherwise would be. Nonetheless, I would have thought that resolving ambiguity about the proper scope of immunity is why the Supreme Court took this case and thought they needed to take it, and yet we actually have even more ambiguity than before. Not great work for the lightning docket, if you want to call it that. The lightning didn't strike in the right place, so to speak. Finally, some implications of this for the future. Obviously, it will almost certainly delay Trump's trial past the November election if the trial ever happens. I won't dwell on that because I'm sure lots of people have pointed it out better than I could. A second problem is that I worry that depending on how these ambiguities shake out, you could have a roadmap for presidential criminality. There's already the passage says, well, if you're discussing things with DOJ officials, maybe that's absolutely excluded from any case against you. So the president could potentially exploit that. He could also, depending on what the meaning of core function turns out to be, he could try to make use of officials' quotes to core function, though there, I think there's more ambiguity than some, such as Judge Sugarman, have suggested, in that maybe a core function is anything having to do with a commander-in-chief power, but maybe a core function is only that which is completely exclusive to the president. And here, Congress has power of its own. There is the clause which says that they have the power to make rules for the government and regulation of the land and naval forces, which historically has included rules about war crimes. So maybe, at least when it comes to ordering things that look like war crimes, there's not an exclusive core power. The answer to this question, the Supreme Court doesn't really give us. It could be argued either way. So nonetheless, when this is made somewhat clear, there could be a very dangerous kind of roadmap. However, I went with this, which is that I think this is a bad decision, and I would have gone the other way and simply said that official acts can be criminalized and that there's nothing preventing that. In that respect, I'm largely close to the DC Circuit and the dissent. I think there's less of a change that this decision makes than some might think, in that it's notable to me, as many have said, that this is the first time that a president has ever been criminally prosecuted for things that he did in office. And I would maintain that's not because no past presidents ever did stuff that could reasonably be considered a crime. There are many, many examples, the Japanese internments, the Palmer raids, many civil liberties violations under FDR and other presidents. For that matter, with Trump himself, I would maintain that the family separation policy, which courts ruled illegal, is the kind of thing that does deserve criminal prosecution. I think Trump should be in prison for the rest of his life for the things he did there. The only reason why not is because there's various official immunity doctrines, which, like yesterday's doctrine, don't have much basis in the text or original meaning of the Constitution. So we have gone over 200 years with various types of presidential criminality that was not punished. It's debatable whether, or even prosecuted, it's debatable whether that was for legal reasons or political reasons or some combination thereof. Others could speak better to that than me. But unfortunately, it looks like presidential impunity for criminal activity is something that has been the rule rather than an exception for most of our history. Maybe it would have been good if these Trump prosecutions would change that, which is a reason to decry yesterday's decision. But it would be a mistake to say that yesterday's decision suddenly created a new reality where presidents are exempt from prosecution, whereas before the understanding was that if they did something significantly criminal, they would be prosecuted. So I'll stop there, and I'm sorry for running past the the 8:45 time, but that's one of the problems of being the last speaker, that risk exists.
No problem. And thank you so much for your participation. Thank you to all the speakers. Two concluding points. First, we end in the middle of a discussion, but that was going to be inevitable with the opinion that we got from the court. This conversation will be ongoing. Hopefully other pieces of it can be at Seattle U with many of these same speakers. Second, I just want, in giving my thanks, to let the audience understand, many of you are lawyers and law professors, but some of you aren't, kind of what an extraordinary effort it is on behalf of these speakers to put on these rapid response webinars. It's the second one we've done. And everybody's up here speaking eloquently about every detail and line of the opinion and locating it in their scholarship and locating it in precedent and in history. And you can lose sight of the fact that this decision came down 24 hours ago, that everyone has processed these 110 pages to the extent that they have in that short time frame. It's easy to sound eloquent when you have months and years to process legal developments. When it's the next day, it's above and beyond. So thank you so much to all of our panelists on both panels. And that concludes our webinar. So take care, everybody.